Section 33 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by ShrimpPhish. Commentaries on American Law, Volume 1, by James Kent. Part 2 of the Government and Constitutional Jurisprudence of the United States. Of Constitutional Restrictions on the Powers of the Several States. Part 2. Cessio Bonorum. And while on this point, it may not be amiss to observe that the Cessio Bonorum of the Roman law, introduced by Julius Caesar, and which prevails at present in most parts of the continent of Europe, only exempted the person of the debtor from imprisonment. It did not release or discharge the debt, or exempt the future acquisitions of the debtor from execution for the debt. The English Statute of 32 George II, commonly called the Lord's Act, and the more recent English statutes of 33 George III, 1 George IV, 3 George IV, and 5 George IV, have gone no further than to discharge the debtor's person, and it may be laid down as the law of Germany, France, Holland, Scotland, England, etc., that insolvent laws are not more extensive in their operation than the Cessio Bonorum of the civil law. In many parts of Germany, as we are informed by Huberus and Heinesius, a Cessio Bonorum does not even work a discharge of the debtor's person, and much less of his future property. The cession under the Roman law did not extend to protect the debtor from personal responsibility for penalties accruing on the commission of crimes. Si in oere non habeat, in pelle luit. But in Germany, the Cessio Bonorum has the severe operation of depriving the insolvent of his remedy for a personal trespass committed prior to the cession. No state can pass naturalization laws. By the Constitution of the United States, Congress have power to establish a uniform rule of naturalization. It was held in the Circuit Court of the United States at Philadelphia in 1792, in Collette v. Collette, that the state governments still enjoyed a concurrent authority with the United States upon the subject of naturalization, and that, though they could not contravene the rule established by Congress, or exclude those citizens who had been made such by that rule, yet that they might adopt citizens upon easier terms than those which Congress may deem it expedient to impose. But though this decision was made by 2 of the judges of the Supreme Court, with the concurrence of the District Judge of Pennsylvania, it is obvious that this opinion was hastily and inconsiderately declared. If the construction given to the Constitution in this case was the true one, the provision would be, in a great degree, useless, and the policy of it defeated. The very purpose of the power was exclusive. It was to deprive the states individually of the power of naturalizing aliens according to their own will and pleasure, and thereby giving them the rights and privileges of citizens in every other state. If each state can naturalize upon 1 year's residence, when the Act of Congress requires 5, of what use is the Act of Congress, and how does it become a uniform rule? This decision of the Circuit Court may be considered as in effect overruled. In the same Circuit Court, in 1797, Judge Iredell intimated that if the question had not previously occurred, he should be disposed to think that the power of naturalization operated exclusively as soon as it was exercised by Congress. And in the Circuit Court of Pennsylvania, in 1814, it was the opinion of Judge Washington that the power to naturalize was exclusively vested in Congress. Afterwards, in Chirac v. Chirac, the Chief Justice of the United States observed that it certainly ought not to be controverted, that the power of naturalization was vested exclusively in Congress. In Houston v. Moore, Judge Story mentioned the power in Congress to establish a uniform rule of naturalization, as one which was exclusive on the ground of there being a direct repugnancy or incompatibility in the exercise of it by the states. The weight of authority, as well as of reason, may therefore be considered as clearly in the favor of this latter construction. No state can tax a national bank or stock. The states cannot impose a tax on the national bank or its branches or on national stock. The inability of the states to impede or control, by taxation or otherwise, the lawful institutions and measures of the national government was largely discussed and strongly declared in the case of McCulloch versus the State of Maryland. In that case, the State of Maryland had imposed a tax upon the branch bank of the United States established in that state, and, assuming the bank to be constitutionally created and lawfully established in that state, the question rose on the validity of the state tax. It was adjudged that the state governments had no right to tax any of the constitutional means employed by the government of the Union to execute its constitutional powers, nor to retard, impede, burden, or in any manner control the operations of the constitutional laws enacted by Congress to carry into effect the powers vested in the national government. To define and settle the bounds of the restriction of the power of taxation in the states, and especially when that restriction was deduced from the implied powers of the general government, was a great and difficult undertaking. But it appears to have been, in this instance, most wisely and most successfully performed. It was declared by the court that it was not to be denied, that the power of taxation was to be concurrently exercised by the two governments. But such was the paramount character of the Constitution of the United States, that it had a capacity to withdraw any subject from the action even of this power, and it might restrain a state from any exercise of it which may be incompatible with, and repugnant to, the constitutional laws of the Union. The great principle that governed the case was, that the Constitution, and the laws made in pursuance thereof, were supreme, and that they controlled the Constitution and laws of the respective states, and could not be controlled by them. It was of the very essence of supremacy to remove all obstacles to its action within its own sphere, and so to modify every power vested in subordinate governments as to exempt its own operations from their influence. A supreme power must control every other power which is repugnant to it. The right of taxation in the states extends to all subjects over which its sovereign power extends, and no further. The sovereignty of a state extends to everything which exists by its own authority, or is introduced by its permission. But it does not extend to those means which are employed by Congress to carry into execution their constitutional powers. The power of state taxation is to be measured by the extent of state sovereignty, and this leaves to a state the command of all its resources, and the unimpaired power of taxing the people and property of the state. But it places beyond the reach of state power all those powers conferred on the government of the Union, and all those means which are given for the purpose of carrying those powers into execution. This principle relieves from clashing sovereignty, from interfering powers, from a repugnancy between a right in one government to pull down what there is an acknowledged right in another to build up, from the incompatibility of a right in one government to destroy what there is a right in another to preserve. The power to tax would involve the power to destroy, and the power to destroy might defeat and render useless the power to create. There would be a plain repugnance in conferring on one government the power to control the constitutional measures of another, which other, with respect to those very measures, was declared to be supreme over that which exerts the control. If the right of the states to tax the means employed by the general government did really exist, then the declaration that the Constitution and the laws made in pursuance thereof should be the supreme law of the land, would be empty and unmeaning declamation. If the states might tax one instrument employed by the government in the execution of its powers, They might tax every other instrument. They might tax the mail. They might tax the mint. They might tax the papers of the custom house. They might tax judicial process. They might tax all the means employed by the government to an excess which would defeat all the ends of the government. The claim of the states to tax the Bank of the United States was thus denied, and shown to be fallacious, and that there was a manifest repugnancy between the power of Maryland to tax, and the power of Congress to preserve the institution of the branch bank. A tax on the operations of the bank was a tax on the operations of an instrument employed by the government of the Union to carry its powers into execution, and was consequently unconstitutional. A case could not be selected from the decisions of the Supreme Court of the United States superior to this one of McCulloch and the State of Maryland, for the clear and satisfactory manner in which the supremacy of the laws of the Union have been maintained by the court, and an undue assertion of state power overruled and defeated. But the court were careful to declare that their decision was to be received with this qualification, that the states were not deprived of any resources of taxation which they originally possessed, and that the restriction did not extend to a tax paid by the real property of the bank, in common with the real property within the state, nor to a tax imposed upon the interest which the citizens of Maryland might hold in that institution, in common with other property of the same description throughout the state. The decision pronounced in this case against the validity of the Maryland tax was made on the 7th of March, 1819, and it was on the 7th of February preceding that the legislature of the state of Ohio imposed a similar tax, to the amount of $50,000 annually, on the branch bank of the United States established in that state. Notwithstanding this decision, the officers of the state of Ohio proceeded to levy the tax, and that act brought up before the Supreme Court a renewed discussion and consideration of the legality of such a tax. It was attempted to withdraw this case from the influence and authority of the former decision by the suggestion that the Bank of the United States was a mere private corporation, engaged in its own business, with its own views, and that its great end and principal object were private trade and private profit. It was admitted that, if that were the case, the bank would be subject to the taxing power of the state, as any individual would be. But it was not the case. The bank was not created for its own sake, or for private purposes. It has never been supposed that Congress could create such a corporation. It was not a private, but a public corporation, created for public and national purposes, and as an instrument necessary and proper for carrying into effect the powers vested in the government of the United States. The business of lending and dealing in money for private purposes was an incidental circumstance, and not the primary object, and the bank was endowed with this faculty in order to enable it to effect the great public ends of the institution, and without such faculty in business, the bank would want a capacity to perform its public functions. And if the trade of the bank was essential to its character as a machine for the fiscal operations of the government, that trade must be exempt from state control, and a tax upon that trade bears upon the whole machine, and was, consequently, inadmissible and repugnant to the Constitution. In Weston versus the City Council of Charleston, it was decided that a state tax on stock issued for loans made to the United States was unconstitutional. The court considered it to be a tax on the power given to Congress to borrow money on the credit of the United States, and thereby to diminish the means of the United States, used in the exercise of its powers, and that it was, consequently, repugnant to the Constitution. By declaring the powers of the general government supreme, the Constitution has shielded its action, and the exercise of its powers, from any restraining or controlling action of the local governments. Places ceded to the United States. The state governments have no jurisdiction in places ceded to the United States. The state governments may likewise lose all jurisdiction over places purchased by Congress, by the consent of the legislature of the state, for the erection of forts, dockyards, lighthouses, hospitals, military academies, and other needful buildings. The question which has arisen on this subject was as to the effect of the proviso or reservation, usually annexed to the consent of the state, that all civil and criminal process issued under the authority of the state might be executed on the lands so ceded, in like manner as if the cession had not been made. This point was much discussed in the Circuit Court of the United States and Rhode Island, in the case of the United States versus Cornell. It was held that a purchase of lands within the jurisdiction of a state, with the consent of the state, for the national purposes contemplated by the Constitution, did, ipso facto, by the very terms of the Constitution, fall within the exclusive legislation of Congress, and that the state jurisdiction was completely ousted. What, then, is the true intent and effect of the saving clause annexed to the cessions? It does not imply the reservation of any concurrent jurisdiction or legislation, or that the state retained a right to punish for acts done within the ceded lands. The whole apparent object of the proviso was to prevent the ceded lands from becoming a sanctuary for fugitives from justice, for acts done within the acknowledged jurisdiction of the state, and such permission to execute process is not incompatible with exclusive sovereignty and jurisdiction. The acceptance of a cession with this reservation amounts to an agreement of the new sovereign to permit the free exercise of such process, as being quoad hoc his own process. This construction has been frequently declared by the courts of the United States, and it comports entirely with the intention of the parties, and upon any other construction the cession would be nugatory and void. Judge Story doubted whether Congress were even at liberty, by the terms of the Constitution, to purchase lands with the consent of a state, under any qualification of that consent, which would deprive them of exclusive legislation over the place. The courts of the United States have sole and exclusive jurisdiction over an offense committed within a ceded place, notwithstanding the ordinary reservation of the right to execute civil and criminal process of the state. That was no reservation of any sovereignty or jurisdiction. Congress, in exercising powers of exclusive legislation over a ceded place or district, unite the powers of general with those of local legislation. The power of local legislation carries with it, as an incident, the right to make that power effectual. Congress exercises that particular local power, like all its other powers, in its high character as the legislature of the Union, and its general power may come in aid of these local powers. It is, therefore, competent for Congress to try and punish an offender for an offense committed within one of those local districts, in a place not within such jurisdiction, or to provide for the pursuit and arrest of a criminal escaping from one of those districts, after committing a felony there, or to punish a person for concealing, out of the district, a felony committed within it. All these incidental powers are necessary to the complete execution of the principal power, and the Supreme Court, in Cohens v. Virginia, held that they were vested in Congress. It follows, as a consequence, from this doctrine of the federal courts, that state courts cannot take cognizance of any offenses committed within such ceded districts, and, on the other hand, that the inhabitants of such places cannot exercise any civil or political privileges under the laws of the state, because they are not bound by those laws. This has been so decided in the state courts. But if, in any case, the United States have not actually purchased, and the state has not, in point of fact, ceded the place or territory to the United States, its jurisdiction remains, notwithstanding the place may have been occupied, ever since its surrender by Great Britain, by the troops of the United States, as a fort or garrison. The Supreme Court of New York accordingly held, in the case of the People versus Godfrey, that they had jurisdiction of a murder committed by one soldier upon another within Niagara Fort, nor would the purchase of the land by the United States be alone sufficient to vest them with the jurisdiction, or to oust that of the state, without being accompanied or followed with the consent of the legislature of the state. This was so decided in the case of the Commonwealth of Pennsylvania versus Young. End of section 33.
Section 34 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Commentaries on American Law, Volume 1, by James Kent. Of Constitutional Restrictions on the Powers of the Several States, Part 3. Power to Regulate Commerce. 8. The construction of the power of Congress to regulate commerce among the several states. I proceed next to examine the judicial decisions under the power given to Congress to, quote, regulate commerce with foreign nations and among the several states, end quote. And it will be perceived that the questions arising under this power have been of the utmost consequence to the interests of the Union and the residuary claims and sovereignty of the states. The first question that arose upon this part of the Constitution was respecting the power of Congress to interrupt or destroy the commerce of the United States by laying a general embargo without any limitation as to time. By the Act of Congress of 22nd December 1807, an embargo was laid on all ships and vessels in the ports and harbors of the United States, and a prohibition of exportation from the United States, either by land or water, of any goods, wares, or merchandise of foreign or domestic growth or manufacture. There were several supplementary acts auxiliary to this principal one, and intended more effectually to enforce it under certain specific exceptions. In the case of the United States versus the Brigantine William, in the District Court of Massachusetts in September 1808, it was objected that the act was unconstitutional, for that Congress had no right, under the power to regulate commerce, thus to annihilate it, by interdicting it entirely with foreign nations. But the court decided that the Embargo Act was within the constitutional provision. The power of Congress was sovereign relative to commercial intercourse, qualified by the limitations and restrictions expressed in the Constitution, and by the treaty-making power of the President and Senate. Congress had a right to control or abridge commerce for the advancement of great national purposes. Non-intercourse and embargo laws are within the range of legislative discretion, and if Congress have the power for purposes of safety or preparation or counteraction to suspend commercial intercourse with foreign nations, they are not limited as to the duration, more than as to the manner and extent of the measure. Footnote. Mr. Justice Story says that the measure of a general embargo, indefinite as to time, as that laid in 1807, went to the utmost verge of implied constitutional power. Commentaries, Volume 3, page 163. End of footnote. A still graver question was presented for the consideration of the federal judiciary in the case of Gibbons versus Ogden, decided by the Supreme Court of the United States in February term 1824. That decision went to declare that several acts of the legislature of New York, granting to Livingston and Fulton the exclusive navigation of the waters of the state in vessels propelled by steam, were unconstitutional and void acts, and repugnant to the power given to Congress to regulate commerce, so far as those acts went to prohibit vessels licensed under the laws of Congress for carrying on the coasting trade from navigating the waters of New York. It had been decided in the Court of Errors of New York in 1812 that 5 several statutes of the state passed between the years 1798 and 1811 inclusive, and granting and securing to the claimants the sole and exclusive right of using and navigating boats by steam in the waters of the state for a term of years, were constitutional and valid acts. According to the doctrine of the court in that case, the internal commerce of the state by land and water remained entirely and exclusively within the scope of its original sovereignty. It was considered to be very difficult to draw an exact line between those regulations which relate to external and those which relate to internal commerce, for every regulation of the one will indirectly or directly affect the other. But it was supposed that there could be no doubt that the acts of the state which were then under consideration were not within any constitutional prohibition, for not one of the restrictions upon state power contained in the 9th and 10th sections of the first article of the Constitution appeared to apply to the case, nor was there any existing regulation of Congress on the subject of commerce with foreign nations, and among the several states which was deemed to interfere with the grant, it was declared to be a very inadmissible proposition that a state was divested of a capacity to grant an exclusive privilege of navigating a steamboat within its own waters, merely because Congress, in the plenary exercise of its power to regulate commerce, might make some future regulation inconsistent with the exercise of that privilege. The grant was taken undoubtedly subject to such future commercial regulations as Congress might lawfully prescribe, and to what extent they might lawfully prescribe them was admitted to be a question within the ultimate cognizance of the Supreme Court of the United States. The opinion of the court went no farther than to maintain that the grant to Livingston and Fulton was not within any constitutional prohibition upon the states, nor was it repugnant or contradictory to any existing act of Congress on the subject of commerce, and under those 2 restrictions every state had a right to make its own commercial regulations. It was generally declared that Congress had not, in the understanding of the court, any direct jurisdiction over our interior commerce or waters, and that they had concurrent jurisdiction over our navigable waters, only so far as might be incidental and requisite to the due regulation of commerce between the states and with foreign nations. In this case, in 1812, the defendants who objected to the validity of the state grant did not set up any patent right or any other right under any particular act of Congress. They rested entirely on the objection that the statutes conferring the exclusive privilege were absolutely unconstitutional and void. But afterwards, in the case of Ogden v. Gibbons, the defendant set up by way of right and title to navigate a steamboat upon the waters of New York in opposition to the grant, that his boats were duly enrolled and licensed under the laws of the United States at Perth Amboy, in the state of New Jersey, to be employed in carrying on the coasting trade. The question in that case was whether such a coasting license conferred any power to interfere with the grant, and it was decided in the Court of Chancery, and afterwards in the Court of Errors, that the coasting license merely gave to the steamboat an American character for the purpose of revenue, and that it was not intended to decide a question of property, or to confer a right of property, or a right of navigation or commerce. The Act of Congress regulating the coasting trade was never intended to assert any supremacy over state regulations or claims in respect to internal waters or commerce. It was not considered by our courts as the exercise of the power of Congress to regulate commerce among the states. The law concerning the coasting trade was passed on the 18th of February, 1793, and it never occurred to anyone during the whole period that the state laws were under consideration before the legislature, and in the Council of Revision, and in the Courts of Justice, from 1798 down to and including the judicial investigations in 1812, that the Coasting Act of 1793 was a regulation of commerce among the states, prohibitory of any such grant. Such latent powers were never thought of, nor imputed to it. The great objects and policy of the Coasting Act were to exclude foreign vessels from commerce between the states, in order to cherish the growth of our own marine and to provide that the coasting trade should be conducted with security to the revenue. The register and enrollment of the vessel were to ascertain the national character, and the license was only evidence that the vessel had complied with the requisites of the law and was qualified for the coasting trade under American privileges. The license did not define the coasting trade. Free trade between the states then existed, subject to local and municipal regulations. The requisitions of the Coasting Act were restrictions upon the general freedom of that commerce, and not the grant of new rights. Steam vessels were subject to those regulations equally with any other vessels. If Congress had intended that a coasting license should confer power and control, and a claim of sovereignty subversive of local laws of the states within their own jurisdictions, it was supposed they would have said so in plain and intelligible language, and not have left their claim of supremacy to be hidden from the observation and knowledge of the state governments in the unpretending and harmless shape of a coasting license, obviously intended for other purposes. It was, therefore, upon considerations like these that the courts of justice in New York did not consider the grant to Livingston and Fulton as disturbed by a coasting license under the Act of 1793. They did not either in the case of Ogden v. Gibbons or in any of the cases which preceded it deny to Congress the power to regulate commerce among the states by express and direct provisions so as to control and restrict the exercise of the state grant. They only insisted that, without some such explicit provision, the state jurisdiction over the subject remained in full force. This cause was afterwards carried up by appeal to the Supreme Court of the United States, and the decree reversed on the ground that the grant was repugnant to the rights and privileges conferred upon a steamboat navigating under a coasting license. In the construction of the power to regulate commerce, the court held that the term meant not only traffic but intercourse, and that it included navigation, and the power to regulate commerce was a power to regulate navigation. Commerce among the several states meant commerce intermingled with the states, and which might pass the external boundary line of each state and be introduced into the interior. It was admitted that the power did not extend to that commerce which was completely internal and carried on between different ports of the same state, and which did not extend to or affect other states. The power was restricted to that commerce which concerned more states than one, and the completely internal commerce of a state was reserved for the state itself. The power of Congress on this subject comprehended navigation within the limits of every state, and it might pass the jurisdictional line of a state and be exercised within its territory, so far as the navigation was connected with foreign commerce, or with commerce among the several states. This power, like all the other powers of Congress, was plenary and absolute within its acknowledged limits. But it was admitted that inspection laws relative to the quality of articles to be exported, and quarantine laws, and health laws of every description, and laws for regulating the internal commerce of a state, and those with respect to turnpike roads, ferries, etc., were component parts of an immense mass of legislation not surrendered to the general government. Though Congress may license vessels to sail from one port to another in the same state, the Act is supposed to be necessarily incidental to the power expressly granted to Congress, and it implies no claim of a direct power to regulate the purely internal commerce of a state, or to act directly on its system of police. The court construed the word regulate to imply full power over the thing to be regulated, and to exclude the action of all others that would perform the same operation on the same thing. After laying down these general propositions, the court proceeded to observe that the acts of New York, granting exclusive privileges to certain steamboats, were in collision with the acts of Congress regulating the coasting trade, and that the acts of the state must in that case yield to the supreme or paramount law. If the law of Congress was made in pursuance of the Constitution, the state laws must yield to the supremacy of it, even though they were enacted in pursuance of powers acknowledged to remain in the states. A license under the Acts of Congress for regulating the coasting trade was an authority to carry on that trade. the words of the Act of Congress directing the proper officer to grant to a vessel qualified to receive it, quote, a license for carrying on the coasting trade, end quote, was considered as conveying an explicit authority for that purpose. It was the legislative grant of a right, and it conferred all the right which Congress could give in the case, and it was not intended to confer merely the national character. It was further held that the power to regulate commerce extended to navigation, carried on by vessels exclusively employed in transporting passengers, and to vessels propelled by steam, as well as to vessels navigated by other means. This is the substance of the argument of the Supreme Court of the United States in the steamboat case. The only great point on which the Supreme Court of the United States and the courts of New York have differed is in the construction and effect given to a coasting license. They did not differ in any general view of the powers of Congress, and the Supreme Court expressly waived any inquiry or decision on the point, whether the exercise of the power assumed by the steamboat laws would have been illegal, provided there was no existing regulation of Congress that came in collision with them. The decision in Livingston v. Van Ingen rested upon the assumption that there was no such regulation. The Court of Errors of New York, since the case of Gibbons v. Ogden, have given to it a very liberal extent by the construction put upon a coasting trade. In that decision, the power to regulate commerce among the several states was supposed to be, quote, very properly restricted to that commerce which concerns more states than one, and that it did not comprehend that commerce which was completely internal, which is carried on between man and man in a state, or between different parts of the same state, and which does not extend to or affect other states, end quote. But in the case in New York alluded to, the Court of Errors held that the coasting trade meant, amongst other things, commercial intercourse carried on between different districts in the same state, and between different places in the same district, on the sea coast, or on a navigable river, and that a voyage from New York to Albany was as much a coasting voyage as from Boston to New Bedford. Under the power to regulate commerce, it has been further decided that a state law requiring every importer of goods by wholesale, bale, or package to take out a license and pay for it under certain penalties or forfeitures for neglect or refusal was repugnant to the Constitution of the United States and void, inasmuch as it belonged to Congress to regulate foreign commerce, and no state can lay a duty on imposts. But it was admitted in that case that after the goods had become mixed with or incorporated into the general mass of the property of the state, they were liable to state taxation. Footnote. In Cumming v. Corporation of Savannah, it was decided by one of the Superior Courts of Georgia in 1816 that the levy of a tax under a city ordinance founded on a state law on all goods, not the produce of the state, and sold on commission, was lawful, as not being a duty on imports. It was further decided in Green v. the City of Savannah that the right to tax imports as well as exports for the purpose of executing inspection laws resided in the states. End of footnote. The restriction does not apply to goods imported and in the hands of the retail trader. In connection with this subject, it may be further observed that by the Constitution of the United States, quote, no state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and all such laws shall be subject to the revision and control of Congress. End quote. Inspection laws are not, strictly speaking, regulations of commerce. Their object is to improve the quality of articles produced by the labor of the country and to fit them for exportation or for domestic use. These laws act upon the subject before it becomes an article of commerce. Inspection laws, quarantine laws, and health laws, as well as laws for regulating the internal commerce of a state, are component parts of the immense mass of residuary state legislation, and over which Congress have no direct power, though it may be controlled when it directly interferes with their acknowledged powers. Footnote. In the case of the City of New York versus Milne, 11 Peters 102, it was decided that a law of New York requiring under a penalty the master of every vessel from any port out of the state to report in writing within 24 hours after his arrival the names, ages, and last legal settlement of the passengers was not a regulation of commerce but of police, and was a constitutional and valid law. The case received a very elaborate discussion, but it is rather difficult, as I apprehend, to exempt the New York law from the character of a regulation of commerce, or to withdraw the case out of the reach of the former doctrines of the court, that the power to regulate commerce with foreign nations is, and necessarily must be, exclusive in the government of the United States. End of footnote. It has been held that if Congress, in the execution of the power to regulate commerce, should pass a statute controlling state legislation in erecting dams over small navigable creeks where the tide ebbs and flows, it would be valid and binding. But until Congress had actually exercised their power over the subject, the state legislation in that case was not considered as repugnant to the power in Congress, in its dormant state, to regulate commerce. It is admitted, however, that the grant to Congress to regulate commerce on the navigable waters of the several states contains no cession of territory or of public or private property, and that the states may, by law, regulate the use of fisheries and oyster beds within their territorial limits, though upon navigable waters, provided the free use of the waters for purposes of navigation and commercial intercourse be not interrupted. Progress of the National Jurisprudence. I have now finished the second general division of this course of lectures, relating to the government and constitutional jurisprudence of the United States, though I have considered the subject in a spirit of free and liberal inquiry, as the series of decisions in the federal courts have been brought under examination, I have uniformly felt, and it has been my invariable disposition to inculcate, a strong sentiment of deference and respect for the judicial authorities of the Union. No point or question of any moment touching the construction of the powers of the government, and which has received an authoritative determination, has been intentionally omitted. There are several important constitutional questions which remain yet to be settled, but if we recur back to the judicial annals of the United States since the year 1800, we shall find that many of the most interesting discussions which had arisen, and which were of a nature to affect deeply the tranquillity of the nation, have auspiciously terminated. The definition of direct taxes within the intendment of the Constitution, the extent of the power of Congress to regulate commerce with foreign nations and among the several states, the power to establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies, the power of Congress over the militia of the states, their power of exclusive legislation over districts and ceded places, the mass of implied powers incidental to the express powers of Congress, such as the power to institute and protect an incorporated bank, to lay a general and indefinite embargo, and to give to the United States as creditor priority of payment, have all received elaborate discussion in the Supreme Court, and they have to a certain extent been ascertained and defined by judicial decisions. So also the extent of the constitutional prohibitions upon the states not to pass ex post facto laws, and not to pass laws impairing the obligation of contracts, and not to impede or control by taxes or grants or any other exercise of power the lawful authorities or institutions or rights and privileges depending on the Constitution and laws of the United States, has been explored and declared by a series of determinations which have contributed in an eminent degree to secure and consolidate the Union, and to elevate the dignity and enlarge the influence of the national government. The power of the President to remove all executive officers in his sound discretion has been settled, not indeed judicially, but perhaps as effectually by the declared sense of the legislature, and the uniform acquiescence and practice of the government. The absolute and uncontrollable efficacy of the treaty-making power has also been definitively established after a struggle against it on the part of the House of Representatives, which at one time threatened to disturb the very foundations of the Constitution. The comprehensive claims of the judicial power as being coextensive with all cases that can arise under the Constitution and laws and treaties of the Union have in several instances been powerfully and successfully vindicated. The appellate jurisdiction of the Supreme Court over the judgments and decrees of the state courts under certain circumstances was defined with great accuracy and precision in the 25th section of the Act of 1789 establishing the judicial courts, and the free and independent exercise of that jurisdiction, so essential to the maintenance of the authority and efficiency of the government of the United States in criminal as well as in civil cases, has been hitherto happily sustained. The means of enforcing obedience when not voluntarily rendered to the decision of this appellate jurisdiction have not been required to be practically applied, and therefore it is a question which the Court has not thought it incumbent on them as yet to decide, whether the exercise of that jurisdiction would permit compulsory process to the state courts, with the ordinary methods of enforcing process. The Act of Congress provided only that on appeal from the judgment or decree of a state court, the writ of error should have the same effect as if the judgment or decree had been rendered or passed in a circuit court, and the proceeding upon a reversal should be the same, except that the Supreme Court, instead of remanding the cause for a final decree, may at their discretion, if the cause shall have been once remanded before, proceed to a final decision of the same and award execution. And with respect to other branches of the judicial power, it may be generally observed that the extensive sway of admiralty and maritime jurisdiction, the character of the parties necessary to give cognizance to the federal courts, the faith and credit which are to be given in each state to the records and judicial proceedings in every other state, the sovereignty of Congress over all its territories without the bounds of any particular state, and the entire and supreme authority of all the constitutional powers of the nation, when coming in collision with any of the residuary or asserted powers of the states, have all been declared, as we've seen in the course of these lectures, by an authority which claims our respect and obedience. In the first 10 or 12 years after the institution of the national judiciary, or from 1790 to 1801, the scanty decisions of the Supreme Court are almost all to be found in the third volume of Dallas's reports. The first great and grave question which came before them was that respecting the liability of a state to be sued by a private creditor, and it is a little remarkable that the Court in one of its earliest decisions should have assumed a jurisdiction which the author of the Federalist had, a few years before, declared to be without any color of foundation. During the period I have mentioned, the federal courts were chiefly occupied with questions concerning their admiralty jurisdiction, and with political and national questions growing out of the Revolutionary War and the dangerous influence and action of the War of the French Revolution upon the neutrality and peace of our country. It was during this portion of our judicial history that the principles of the doctrines of expatriation, of ex post facto laws, of constitutional taxes, and of the construction and obligation of the Treaty of 1783 upon the rights of the British creditors were ably discussed and firmly declared. The reports of Mr. Cranch commenced with the year 1801, and the 9 volumes of those reports cover the business of a very active period down to the year 1815. The Supreme Court was occupied with many great and momentous questions, and especially during that portion of the time in which the United States had abandoned their neutral and assumed a belligerent character. It is curious to observe in these reports the rapid cultivation and complete adoption of the law and learning of the English Admiralty and Prize Courts, notwithstanding those courts had been the constant theme of complaint and obloquy in our political discussions for the 15 years preceding the war. In the last 3 volumes of Mr. Cranch, the Court was constantly dealing with great questions, embracing the rights and the policy of nations, and the prize and maritime law, not of England only, but of all the commercial nations of Europe, was suddenly introduced and deeply and permanently interwoven with the municipal law of the United States. We perceive also in these volumes the constant growth and accumulation of cases on commercial law generally, and relating to policies of insurance, negotiable paper, mercantile partnerships, and the various customs of the law merchant. The court was likewise busy in discussing and settling important principles growing out of the limited range of other matters of federal cognizance, and relating to the law of evidence, to frauds, trusts, and mortgages. They were engaged also with the doctrine of the limitation of suits, the contract of sale, and with the more enlarged subjects of domicile, of the lex loci, of neutrality, and of the numerous points of international law. By the time of the commencement of Mr. Wheaton's reports in 1816, the decisions of the Supreme Court had embraced so many topics of public and municipal law, and those topics had been illustrated by so much talent and learning, that, for the first time in the history of this country, we were enabled to perceive the broad foundations and rapid growth of a code of national jurisprudence. That code has been growing and improving ever since, and it has now become a solid and magnificent structure, and it seems destined at no very distant period of time to cast a shade over the less elevated, and perhaps we must add, the less attractive and ambitious systems of justice in the several states. The most interesting parts of Mr. Wheaton's reports are those which contain the examination of those great constitutional questions which we have been reviewing, and I cannot conceive of anything more grand and imposing in the whole administration of human justice than the spectacle of the Supreme Court sitting in solemn judgment upon the conflicting claims of the national and state sovereignties, and tranquilizing all jealous and angry passions, and binding together this great confederacy of states in peace and harmony by the ability, the moderation, and the equity of its decisions. There are several reasons why we may anticipate the still increasing influence of the federal government, and the continual enlargement of the national system of law in magnitude and value. The judiciary of the United States has an advantage over many of the state courts in the tenure of the office of the judges and the liberal and stable provision for their support. The United States are by these means fairly entitled to command better talents and to look for more firmness of purpose, greater independence of action, and brighter displays of learning. The federal administration of justice has a manifest superiority over that of the individual states, in consequence of the uniformity of its decisions and the universality of their application. Every state court will naturally be disposed to borrow light and aid from the national courts, rather than from the courts of other individual states, which will probably never be so generally respected and understood. The states are multiplying so fast, and the reports of their judicial decisions are becoming so numerous, that few lawyers will be able or willing to master all the intricacies and anomalies of local law existing beyond the boundaries of their own state. 24 independent state courts of the final jurisdiction over the same questions, arising upon the same general code of common and of equity law, must necessarily impair the symmetry of that code. The danger to be apprehended is that students will not have the courage to enter the complicated labyrinth of so many systems, and that they will of course entirely neglect them and be contented with the knowledge of the law of their own state, and the law of the United States, and then resort for further assistance to the never-failing fountains of European wisdom. But though the national judiciary may be deemed preeminent in the weight of its influence, the authority of its decisions, and in the attraction of their materials, there are abundant considerations to cheer and animate us in the cultivation of our own local law. The judicial power of the United States is necessarily limited to national objects. The vast field of the law of property, the very extensive head of equity jurisdiction, and the principal rights and duties which flow from our civil and domestic relations fall within the control, and we might almost say the exclusive cognizance of the state governments. We look essentially to the state courts for protection to all these momentous interests. They touch in their operation every chord of human sympathy and control our best destinies. It is their province to reward and to punish. Their blessings and their terrors will accompany us to the fireside and be in constant activity before the public eye. The elementary principles of the common law are the same in every state, and equally enlighten and invigorate every part of our country. Our municipal codes can be made to advance with equal steps with that of the nation in discipline, in wisdom, and in luster, if the state governments, as they ought in all honest policy, will only render equal patronage and security to the administration of justice. The true interests and the permanent freedom of this country require that the jurisprudence of the individual states should be cultivated, cherished, and exalted, and the dignity and reputation of the state authorities sustained with becoming pride. In their subordinate relation to the United States, they should endeavor to discharge the duty which they owe to the latter, without forgetting the respect which they owe to themselves. In the appropriate language of Sir William Blackstone, and which he applied to the people of his own country, they should be, quote, loyal yet free, obedient and yet independent. End quote. End of section 34. Read by Czandra, near Montreal in Canada, 2026.
Section 35 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of Statute Law, Part 1. Lecture 20 of Statute Law. Municipal law is a rule of civil conduct prescribed by the supreme power of the state. It is composed of written and unwritten, or statute and common law. Statute law is the express written will of the legislature, rendered authentic by certain prescribed forms and solemnities. It is a principle in the English law that an act of Parliament delivered in clear and intelligible terms cannot be questioned or its authority controlled in any court of justice. It is, says Sir William Blackstone, the exercise of the highest authority that the kingdom acknowledges upon earth. When it is said in the books that a statute contrary to natural equity and reason, or repugnant or impossible to be performed, is void, the cases are understood to mean that the courts are to give the statute a reasonable construction. They will not readily presume, out of respect and duty to the lawgiver, that any very unjust or absurd consequence was within the contemplation of the law. But if it should happen to be too palpable in its direction to admit of but one construction, there is no doubt in the English law as to the binding efficacy of the statute. The will of the legislature is the supreme law of the land and demands perfect obedience. But while we admit this conclusion of the English law, we cannot but admire the intrepidity and powerful sense of justice which led Lord Coke, when Chief Justice of the KB, to declare as he did in Dr. Bonham's case, that the common law doth control acts of Parliament, and adjudges them void when against common right and reason. The same sense of justice and freedom of opinion led Lord Chief Justice Hobart in Day v. Savage to insist that an act of Parliament made against natural equity as to make a man judge in his own case was void. It induced Lord Chief Justice Holt to say in the case of the City of London v. Wood that the observation of Lord Coke was not extravagant, but was a very reasonable and true saying. Perhaps what Lord Coke said in his reports on this point may have been one of the many things that King James alluded to when he said that in Coke's reports there were many dangerous conceits of his own uttered for law, to the prejudice of the Crown, Parliament, and subjects. Laws repugnant to the Constitution void. The principle in the English government that the Parliament is omnipotent does not prevail in the United States. Though, if there be no constitutional objection to a statute, it is with us as absolute and uncontrollable as laws flowing from the sovereign power under any form of government. But in this and all other countries where there is a written constitution designating the powers and duties of the legislative, as well as the other departments of the government, an act of the legislature may be void as being against the Constitution. The law with us must conform, in the first place, to the Constitution of the United States, and then to the subordinate constitution of its peculiar state, and if it infringes the provisions of either, it is so far void. The courts of justice have a right, and are in duty bound, to bring every law to the test of the Constitution, and to regard the Constitution, first of the United States, and then of their own state, as the paramount or supreme law, to which every inferior or derivative power and regulation must conform. The Constitution is the act of the people speaking in their original character and defining the permanent conditions of the social alliance. And there can be no doubt on the point with us that every act of the legislative power, contrary to the true intent and meaning of the Constitution, is absolutely null and void. Power of the judiciary to declare them void. The judicial department is the proper power in the government to determine whether a statute be or be not constitutional. The interpretation or construction of the Constitution is as much a judicial act and requires the exercise of the same legal discretion as the interpretation or construction of a law. To contend that the courts of justice must obey the requisitions of an act of the legislature when it appears to them to have been passed in violation of the Constitution would be to contend that the law was superior to the Constitution, and that the judges had no right to look into it and regard it as the paramount law. It would be rendering the power of the agent greater than that of his principal, and be declaring that the will of only one concurrent and coordinate department of the subordinate authorities under the Constitution was absolute over the other departments and competent to control, according to its own will and pleasure, the whole fabric of the government and the fundamental laws on which it rested. The attempt to impose restraints upon the exercise of the legislative power would be fruitless if the constitutional provisions were left without any power in the government to guard and enforce them. From the mass of powers necessarily vested in the legislature and the active and sovereign nature of those powers, from the numerous bodies of which the legislature is composed, the popular sympathies which it excites, and its immediate dependence upon the people by the means of frequent periodical elections, it follows that the legislative department of the government will have a decided superiority of influence. It is constantly acting upon all the great interests in society and agitating its hopes and fears. It is liable to be constantly swayed by popular prejudice and passion, and it is difficult to keep it from pressing with injurious weight upon the constitutional rights and privileges of the other departments. An independent judiciary, venerable by its gravity, its dignity, and its wisdom, and deliberating with entire serenity and moderation, is peculiarly fitted for the exalted duty of expounding the Constitution and trying the validity of statutes by that standard. It is only by the free exercise of this power that courts of justice are enabled to repel assaults and to protect every part of the government and every member of the community from undue and destructive innovations upon their chartered rights. It has accordingly become a settled principle in the legal polity of this country that it belongs to the judicial power as a matter of right and of duty to declare every act of the legislature made in violation of the Constitution or of any provision of it null and void. The progress of this doctrine and the manner in which it has been discussed and established is worthy of notice. It had been very ably examined in the Federalist, and its solidity vindicated by unanswerable arguments. But it was not until the year 1792 that it seems to have received a judicial consideration. In Hayburn's case, which came before the Circuit Court of the United States for the District of New York in April 1791, the judges proceeded with the utmost delicacy and caution to declare an act of Congress, assigning ministerial duties to the circuit courts, and to be unconstitutional. The court laid down the position that Congress cannot constitutionally assign to the judicial power any duties which are not strictly judicial, and that the act in question was not obligatory upon the court. But they nevertheless proceeded voluntarily in ex gratia as commissioners to execute the duties of the act. In Pennsylvania and North Carolina, the circuit courts of the United States within those districts equally held the act not binding upon them because the legislature had no right or power to assign to them duties not judicial. But they were not so accommodating as the Circuit Court of New York, for they declined to act under the law in any capacity. In 1792, the Supreme Court of South Carolina, in the case of Bowman v. Middleton, went further and set aside an act of the colony legislature as being against common right and the principles of Magna Carta, for it took away the freehold of one man and vested it in another without any compensation or any previous attempt to determine the right. They declared the act to be ipso facto void, and that no length of time could give it validity. This was not strictly a question arising upon any special provision of the state constitution, but the court proceeded upon those great fundamental principles which support all government and property, and which have been supposed by many judges in England to be sufficient to check and control the regulations of an Act of Parliament. The next case in which the power of the judiciary to disregard or set aside a statute for being repugnant to the Constitution was one that came before Judge Patterson at Philadelphia in April 1795. He asserted the duty of the court and the paramount authority of the Constitution in remarkably clear and decided language. That was a case of an act of Pennsylvania which he held to be unconstitutional and not binding. He insisted that the Constitution was certain and fixed and contained the permanent will of the people and was a supreme law and paramount to the power of the legislature and could only be revoked or altered by the authority that made it, that the legislature was the creature of the Constitution and owed its existence to the Constitution, and derived its power from the Constitution, and all its acts must be conformable to it, or else they will be void. The same question afterwards arose before the Supreme Court of South Carolina in the case of Lindsay versus the Charleston Commissioners, and the power of the legislature to take a private property for necessary public purposes, as for a public street, was freely discussed, and though the judges were equally divided on the question whether it was a case in which the party was entitled to compensation, those who held him so entitled held also that the law was unconstitutional and inoperative until the compensation was made. The judges, in exercising that high authority, claimed to be only the administrators of the public will, and the law was void not because the judges had any control over the legislative power, but because the will of the people declared in the Constitution was paramount to that of their representatives expressed in the law. In Whittington v. Polk, it was decided in 1802 by the General Court of Maryland with great clearness and force that an act of the legislature repugnant to the Constitution was void, and that the courts had a right to determine when it was so void. Hitherto, this question, as we have seen, was confined to some of the state courts and to the subordinate or circuit courts of the United States. But in Marbury v. Madison, the subject was brought under the consideration of the Supreme Court of the United States and received a clear and elaborate discussion. The power and duty of the judiciary to disregard an unconstitutional act of Congress or of any state legislature were declared in an argument approaching to the precision and certainty of a mathematical demonstration. The question, said the Chief Justice, was whether an act repugnant to the Constitution can become a law of the land, and it was one deeply interesting to the United States. The powers of the legislature are defined and limited by a written constitution, but to what purpose is that limitation if those limits may at any time be passed? The distinction between a government with limited and unlimited powers is abolished if those limits do not confine the persons on whom they are imposed, and if acts prohibited and acts allowed are of equal obligation. If the Constitution does not control any legislative act repugnant to it, then the legislature may alter the Constitution by an ordinary act. The theory of every government with a written constitution, forming the fundamental and paramount law of the nation, must be that an act of the legislature repugnant to the Constitution is void. If void, it cannot bind the courts and oblige them to give it effect, for this would be to overthrow in fact what was established in theory and to make that operative as law which is not law. It is the province and the duty of the judicial department to say what the law is, and if two laws conflict with each other, to decide on the operation of each. So, if the law be in opposition to the Constitution and both apply to a particular case, the court must either decide the case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law. If the Constitution be superior to an act of the legislature, the courts must decide between these conflicting rules, and how can they close their eyes on the Constitution and see only the law? This great question may be regarded as now finally settled, and I consider it to be one of the most interesting points in favor of constitutional liberty and of the security of property in this country that has ever been judicially determined. There never was any doubt or difficulty in New York in respect to the competency of the courts to declare a statute unconstitutional when it clearly appeared to be so. Thus, in the case of the People v. Platt, the Supreme Court held that certain statutes affecting the right of Z. Platt and his assigns to the exclusive enjoyment of the river Saranac were in violation of vested rights under his patent, and so far the court held them to be unconstitutional, inoperative, and void. The control which the judicial power of the state had until the year 1823 over the passing of laws by the institution of the Council of Revision anticipated in a great degree the necessity of this exercise of duty. A law containing unconstitutional provisions was not likely to escape the notice and objection of the Council of Revision, and the records of that body will show that many a bill which had heedlessly passed the two houses of the legislature was objected to and defeated on constitutional grounds. The records to which I refer are replete with the assertion of salutary and sound principles of public law and constitutional policy, and they will forever remain a monument of the wisdom, firmness, and integrity of the Council. When a statute takes effect. A statute, when duly made, takes effect from its date when no time is fixed, and this is now the settled rule. It was so declared by the Supreme Court of the United States in Matthews v. Zane, and it was likewise so adjudged in the Circuit Court in Massachusetts in the case of the brig Anne. I apprehend that the same rule prevails in the courts of the several states, and that it cannot be admitted that a statute shall, by any fiction or relation, have any effect before it was actually passed. A retroactive statute would partake in its character of the mischiefs of an ex post facto law, as to all cases of crimes and penalties, and in every other case relating to contracts or property, it would be against every sound principle. It would come within the reach of the doctrine that a statute is not to have a retrospective effect, and which doctrine was very much discussed in the case of Dash versus Van Cleek, and shown to be founded not only in English law but on the principles of general jurisprudence. A retrospective statute affecting and changing vested rights is very generally considered in this country as founded on unconstitutional principles and consequently inoperative and void. But this doctrine is not understood to apply to remedial statutes, which may be of a retrospective nature, provided they do not impair contracts or disturb absolute vested rights, and only go to confirm rights already existing and in furtherance of the remedy by curing defects and adding to the means of enforcing existing obligations. Such statutes have been held valid when clearly just and reasonable and conducive to the general welfare, and even though they might operate in a degree upon existing rights, as a statute to confirm former marriages defectively celebrated or a sale of lands defectively made or acknowledged. The legal rights affected in those cases by the statutes were deemed to have been vested subject to the equity existing against them, and which the statutes recognized and enforced. But the cases cannot be extended beyond the circumstances on which they repose without putting in jeopardy the energy and safety of the general principle. The English rule formerly was that if no period was fixed by the statute itself, it took effect by relation from the first day of the session in which the act was passed, and which might be some weeks, if not months, before the act received the royal sanction, or even before it had been introduced into Parliament. This was an extraordinary instance of the doctrine of relation, working gross injustice and absurdity, and yet we find the rule declared and uniformly adhered to from the time of Henry VI. All the judges agreed in the case of Partridge v. Strange in the 6th Edwardian 6th that the statute was to be accounted in law a perfect act from the first day of the session, and all persons were to be punished for an offense done against it after the first day of the session, unless a certain time was appointed when the act should take effect. In the case of the King v. Thurston, this doctrine of carrying a statute back by relation to the first day of the session was admitted in the K.B., though the consequence of it was to render an act of murder which would not have been so without such relation. The case of the Attorney General v. Panter is another strong instance of the application of this rigorous and unjust rule of the common law, even at so late and enlightened a period of the law as the year 1772. An act for laying a duty on the exportation of rice thereafter to be exported received the royal assent on the 29th of June, 1767, and on the 10th of June of that year the defendants had exported rice. After the act passed, a duty of £115 was demanded upon the prior exportation, and it was adjudged in the Irish Court of Exchequer to be payable. The cause was carried by appeal to the British House of Lords on the ground of the palpable injustice of punishing the party for an act innocent and lawful when it was done. But the decree was affirmed upon the opinion of the 12 judges that the statute by legal relation commenced from the first day of the session. The K.B. also in Latlis v. Holmes considered the rule to be too well settled to be shaken, and that the court could not take notice of the great hardship of the case. The voice of reason at last prevailed, and by the statute of 33 George chapter 13, it was declared that statutes are to have effect only from the time they receive the royal assent, and the former rule was abolished to use the words of the statute by reason of its great and manifest injustice. There is a good deal of hardship in the rule as it now stands, both here and in England, for a statute is to operate from the very day it passes, if the law itself does not establish the time. It is impossible in any state, and particularly in such a widespread dominion as that of the United States, to have notice of the existence of the law until some time after it is passed. It would be no more than reasonable and just that the statute should not be deemed to operate upon the persons and property of individuals, or impose pains and penalties for acts done in contravention of it, until the law was duly promulgated. The rule, however, is deemed to be fixed beyond the power of judicial control, and no time is allowed for the publication of the law before it operates, when the statute itself gives no time. Thus, in the case of the brig Anne, the vessel was libelled and condemned for sailing from Newburyport in Massachusetts on the 12th of January, 1808, contrary to the Act of Congress of the 9th of January, 1808. Though it was admitted the act was not known in Newburyport on the day the brig sailed. The court admitted that the objection to the forfeiture of the brig was founded on the principles of good sense and natural equity, and that unless such time be allowed as would enable the party with reasonable diligence to ascertain the existence of the law, an innocent man might be punished in his person and property for an act which was innocent for aught he knew, or could by possibility have known when he did it. The Code Napoleon adopted the true rule on this subject. It declared that laws were binding from the moment their promulgation could be known, and that the promulgation should be considered as known in the department of the imperial residence one day after that promulgation, and in each of the other departments of the French Empire, after the expiration of the same space of time, augmented by as many days as there were distances of 20 leagues between the seat of government and the place. The New York Revised Statutes have also declared the very equitable rule that every law, unless a different time be prescribed therein, takes effect throughout the state on and not before the 20th day after the day of its final passage. If the statute be constitutional in its character and has duly gone into operation, the next inquiry is respecting its meaning, and this leads us to a consideration of the established rules of construction by which its sense and operation are to be understood. Acts, public and private. There is a material distinction between public and private statutes, and the books abound with cases explaining this distinction and its application to particular statutes. It is sometimes difficult to draw the line between a public and private act, for statutes frequently relate to matters and things that are partly public and partly private. The most comprehensive, if not the most precise definition in the English books is that public acts relate to the kingdom at large, and private acts to certain individuals or to particular classes of men. Generally speaking, statutes are public, and a private statute may rather be considered as an exception to a general rule. It operates upon a particular thing or private persons. It is said not to bind or include strangers in interest to its provisions, and they are not bound to take notice of a private act even though there be no general saving clause of the rights of third persons. It is said not to bind or include strangers in interest to its provisions, and they are not bound to take notice of a private act, even though there be no general saving clause of the rights of third persons. This is a safe and just rule of construction, and it was adopted by the English courts in very early times and does great credit to their liberality and spirit of justice. It is supported by the opinion of Sir Matthew Hale in Lucy v. Levington, where he lays down the rule to be that though every man be so far a party to a private act of Parliament as not gainsay it, yet he is not so far a party as to give up his interest. To take the case stated by Sir Matthew Hale, suppose a statute recites that whereas there was a controversy concerning land between A and B, and enacts that A shall enjoy it, this would not bind the interest of third persons in that land, because they are not strictly parties to the act, but strangers, and it would be manifest injustice that the statute should affect them. This rule as to the limitation of the operation of private statutes was adopted by the Supreme Court of New York and afterwards by the Court of Errors in Jackson v. Catlin. It is likewise a general rule in the interpretation of statutes limiting rights and interests not to construe them to embrace the sovereign power or government unless the same be expressly named therein or intended by necessary implication. There is another material distinction in respect to public and private statutes. The courts of justice are bound ex officio to take notice of public acts without their being pleaded, for they are part of the general law of the land, which all persons, and particularly the judges, are presumed to know. Public acts cannot be put in issue by plea. Null teal record cannot be pleaded to a public statute. The judges are to determine the existence of them from their own knowledge, but they are not bound to take notice of private acts unless they be specifically pleaded and shown in proof by the party claiming the effect of them. In England, the existence even of a private statute cannot be put in issue to be tried by a jury, though this may be done in New York under the revised statutes. End of section 35. Section 36 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of Statute Law, Part 2. Rules for the Interpretation of Statutes. The title of the Act and the preamble to the Act are, strictly speaking, no parts of it. They may serve to show the general scope and purport of the Act and the inducements which led to its enactment. They may at times aid in the construction of it, but generally they are very loosely and carelessly inserted, are not safe expositors of the law. The title frequently alludes to the subject matter of the Act only in general or sweeping terms, or it alludes only to a part of the multifarious matter of which the statute is composed. The title, as it was observed in United States v. Fisher, when taken in connection with other parts, may assist in removing ambiguities where the intent is not plain. For when the mind labors to discover the intention of the legislature, it seizes everything, even the title, from which aid can be derived. So the preamble may be resorted to in order to ascertain the inducements to the making of the statute. But when the words of the enacting clause are clear and positive, recourse must not be had to the preamble. Notwithstanding that Lord Coke considers the preamble as a key to open the understanding of the statute, Mr. Barrington, in his Observations on the Statutes, has shown by many instances that a statute frequently recites that which is not the real occasion of the law, or states that doubts existed as to the law when in fact none had existed. The true rule is, as was declared by Mr. J. Buller in Crespini v. Wittenum, that the preamble may be resorted to in restraint of the generality of the enacting clause, when it would be inconvenient if not restrained, or it may be resorted to in explanation of the enacting clause, if it be doubtful. This is the whole extent of the influence of the title and preamble in the construction of the statute. The true meaning of the statute is generally and properly to be sought from the body of the act itself. But such is the imperfection of human language, and the want of technical skill in the makers of the law, that statutes often give occasion to the most perplexing and distressing doubts and discussions, arising from the ambiguity that attends them. It requires a great experience, as well as the command of a perspicuous diction, to frame a law in such clear and precise terms as to secure it from ambiguous expressions, and from all doubt and criticism upon its meaning. It is an established rule in the exposition of statutes that the intention of the lawgiver is to be deduced from a view of the whole and of every part of a statute, taken and compared together. The real intention, when accurately ascertained, will always prevail over the literal sense of terms. Sciri legis non hoc est verba eram tenere sed vim a potestatem, and the reason and intention of the lawgiver will control the strict letter of the law, when the latter would lead to palpable injustice, contradiction, and absurdity. This was the doctrine of Modernistus, Scaviola, Paulus, and Ulipanus, the most illustrious commentators on the Roman law. When the words are not explicit, the intention is to be collected from the context, from the occasion and necessity of the law, from the mischief felt and the objects and the remedy in view, and the intention is to be taken or presumed according to what is consonant to reason and good discretion. These rules, by which the sages of the law, according to Plowden, have ever been guided in seeking for the intention of the legislature, are maxims of sound interpretation, which have been accumulated by the experience and ratified by the approbation of ages. The words of a statute, if of common use, are to be taken in their natural and ordinary signification and import, and if technical words are used, they are to be taken in a technical sense, unless it clearly appears from the context or other parts of the instrument that the words were intended to be applied differently from their ordinary or their legal acceptation. The current of authority at the present day, said Mr. Justice Bronson, is in favor of reading statutes according to the natural and most obvious import of the language, without resorting to subtle and forced constructions, for the purpose of either limiting or extending their operation. A saving clause in a statute is to be rejected when it is directly repugnant to the purview or body of the act, and could not stand without rendering the act inconsistent and destructive of itself. Lord Coke, in Alton Wood's case, gives a particular illustration of this rule by a case which would be false doctrine with us, but which serves to show the force of the rule. Thus, if the manor of Dale be by express words given by statute to the king, saving the right of all persons interested therein, or if the statute vests the lands of A in the king, saving the rights of A, the interest of the owner is not saved, inasmuch as the saving clause is repugnant to the grant. And if it were allowed to operate, it would render the grant vain and nugatory. But there is a distinction in some of the books between a saving clause and a proviso in the statute, though the reason of the distinction is not very apparent. It was held by all the barons of the Exchequer in the case of the Attorney General versus the Governor and Company of Chelsea Water Works, that where the proviso of an Act of Parliament was directly repugnant to the purview of it, the proviso should stand and be held a repeal of the purview, because it speaks the last intention of the lawgiver. It was compared to a will in which the latter part, if inconsistent with the former, supersedes and revokes it. But it may be remarked upon this case of Fitzgibbon, that a proviso repugnant to the purview of the statute renders it equally nugatory and void as a repugnant saving clause. And it is difficult to see why the act should be destroyed by the one and not by the other, or why the proviso and the saving clause, when inconsistent with the body of the act, should not both of them be equally rejected. There is also a technical distinction between a proviso and an exception in a statute. If there be an exception in the enacting clause of a statute, it must be negatived in pleading, but if there be a separate proviso, that need not. Several acts in pari materia and relating to the same subject are to be taken together and compared in the construction of them, because they are considered as having one object in view and acting upon one system. This rule was declared in the cases of Rex v. Loxdale and the Earl of Aylesbury v. Patterson, and the rule applies, though some of the statutes may have expired or are not referred to in the other acts. The object of the rule is to ascertain and carry into effect the intention, and it is to be inferred that a code of statutes relating to one subject was governed by one spirit and policy, and was intended to be consistent and harmonious in its several parts and provisions. Upon the same principle, whenever a power is given by a statute, everything necessary to the making of it effectual, or requisite to attain the end, is implied. Quando lex aliquid concediet, concediere videtur et id, per quod devenitur ad illud. Statutes are likewise to be construed in reference to the principles of the common law, for it is not to be presumed the legislature intended to make any innovation upon the common law further than the case absolutely required. This has been the language of the courts in every age, and when we consider the constant, vehement, and exalted eulogy which the ancient sages bestowed upon the common law as the perfection of reason, and the best birthright and noblest inheritance of the subject, we cannot be surprised at the great sanction given to this rule of construction. It was observed by the judges in the case of Stoll v. Zouch that it was good for the expositors of a statute to approach as near as they could to the reason of the common law, and the resolution of the barons of the Exchequer in Haydon's case was to this effect. For the sure and true interpretation of all statutes, whether penal or beneficial, 4 things are to be considered. What was the common law before the act? What was the mischief against which the common law did not provide? What remedy the Parliament had provided to cure the defect, and the true reason of the remedy? It was held to be the duty of the judges to make such a construction as should repress the mischief and advance the remedy. In the construction of statutes, the sense which the contemporary members of the profession had put upon them is deemed of some importance according to the maxim that Contemporanea exposito est fortissima in lege. Statutes that are remedial and not penal are to receive an equitable interpretation by which the letter of the act is sometimes restrained and sometimes enlarged, so as more effectually to meet the beneficial end in view and prevent a failure of the remedy. This may be illustrated in the case of the Registry Acts, for giving priority to deeds and mortgages according to the dates of the registry. If a person claiming under a registered deed or mortgage had noticed the unregistered prior deed when he took his deed, and procured the registry of it in order to defeat the prior deed, he shall not prevail with his prior registry, because that would be to counteract the intent and policy of the statutes, which were made to prevent and not to uphold frauds. Statutes are sometimes merely directory, and in that case a breach of the direction works no forfeiture or invalidity of the thing done, but it is otherwise if the statute be imperative. Effect of temporary statutes. If an act be penal and temporary by the terms or nature of it, the party offending must be prosecuted and punished before the act expires or be repealed. Though the offense be committed before the expiration of the act, the party cannot be punished after it has expired unless a particular provision be made by law for the purpose. If a statute be repealed and afterwards the repealing act be repealed, this revives the original act. And if a statute be temporary and limited to a given number of years, and before the expiration of the time it be continued by another act, it was formerly a question under which statute, acts, and proceedings were to be considered as done. In the case of the College of Physicians, it was declared that if a statute be limited to 7 years, and afterwards by another statute be made perpetual, proceedings ought to be referred to the last statute as being the one in force. But this decision was erroneous and contrary to what had been said by Popham, Chapter J in Dingley v. Moore, and all acts, civil and criminal, are to be charged under the authority of the first act. Thus, in the case of Rex v. Morgan, on an indictment for perjury in an affidavit to hold the bail, it was laid to have been taken by virtue of the statute of 12 George 1, which was a temporary law for 5 years, and which was afterwards and before the expiration of it, continued by the Act of 5 George 2, with some alterations. Lord Chief Justice Hardwicke said that when an act was continued by a subsequent act, everybody was stopped to say the first act was not in force, and as the act in question was not altered in respect to bail, the offense was properly laid to have been done against the first act. In Shipment v. Henbest, the King's Bench held that if a statute be permitted even to expire and be afterwards revived by another statute, the law derives its force from the first statute, which is to be considered as in operation by means of revival. If, however, a temporary act be revived after it has expired, the intermediate time is lost without a special provision reaching to the intermediate time. Statute penalties. If a statute inflicts a penalty for doing an act, the penalty implies a prohibition, and the thing is unlawful, though there be no prohibitory words in the statute. Lord Holt in Bartlett v. Viner applied this rule to the case of a statute inflicting a penalty for making a particular contract, such as a simoniacal or usurious contract, and he held that the contract was void under the statute, though there was a penalty imposed for making it. The principle is now settled that the statutory prohibition is equally efficacious, and the illegality of a breach of the statute the same, whether a thing be prohibited absolutely or only under a penalty. The New York Revised Statutes make the doing an act contrary to a statute prohibition a misdemeanor, though no penalty be imposed. Whether any other punishment can be inflicted than the penalty given by the statute has been made a serious question. The Court of KB in Rex v. Robinson laid down this distinction that where a statute created a new offense by making unlawful what was lawful before and prescribed a particular sanction, it must be pursued and none other. But where the offense was punishable at common law and the statute prescribed a particular remedy, the sanction was cumulative and did not take away the common law punishment, and either remedy might be pursued. The same distinction had been declared long before, and the proper inquiry in such cases was the doing of the thing, for which the penalty is inflicted, lawful or unlawful, before the passing of the statute. If it was no offense before, the party offending is liable to the penalty and to nothing else. The distinction between statutory offenses which are mala prohibita only or mala in se is now exploded, and a breach of the statute law in either case is equally unlawful and equally a breach of duty, and no agreement founded on the contemplation of either class of offenses will be enforced at law or in equity. There are a number of other rules of minor importance relative to the construction of statutes, and it will be sufficient to observe generally that the great object of the maxims of interpretation is to discover the true intention of the law, and whenever that intention can be indubitably ascertained, and it be not a violation of constitutional right, the courts are bound to obey it, whatever may be their opinion of its wisdom or policy. But it would be quite visionary to expect in any code of statute law such precision of thought and perspicuity of language as to preclude all uncertainty as to the meaning and exempt the community from the evils of vexatious doubts and litigious interpretations. Lord Coke complained that in his day great questions had oftentimes arisen upon acts of Parliament overladen with provisos and additions, and many times on a sudden penned or corrected by men of none or very little judgment in law. Various and discordant readings, glosses, and commentaries will inevitably arise in the progress of time, and perhaps as often from the want of skill and talent in those who comment as in those who make the law. Though the French codes, digested under the revolutionary authority, are distinguished for sententious brevity, there are numerous volumes of French reports already extant upon doubtful and difficult questions arising within a few years after those codes were promulgated. The Emperor Justinian, in one of the edicts which he published in confirmation of the authority of the Pandects, and prefixed to that work, expressly prohibited the civilians of his time, and those of all future ages, from writing any commentary upon his laws. The history of Justinian's reign shows the folly and absurdity of this attempt to bar all future innovation. Greater changes took place in the few years in the laws and jurisprudence of Justinian, said Montesquieu, than in the 300 years of the French monarchy immediately preceding his time, and those changes were so incessant and so trifling that the inconstancy of the emperor can only be explained by having recourse to the secret history of Procopius, where he is charged with having sold equally his judgments and his laws. End of section 36. Section 37 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of Reports of Judicial Decisions, Part 1. Lecture 21. Of Reports of Judicial Decisions. Having considered the nature and force of written law and the general rules which are applied to the interpretation of statutes, we are next to consider the character of unwritten or common law and the evidence by which its existence is duly ascertained. The common law includes those principles, usages, and rules of action applicable to the government and security of person and property, which do not rest for their authority upon any express and positive declaration of the will of the legislature. According to the observation of an eminent English judge, statute law is the will of the legislature in writing, and the common law is nothing but statutes worn out by time, and all the law began by the consent of the legislature. Source of the common law. This is laying down the origin of the common law rather too strictly. A great proportion of the rules and maxims which constitute the immense code of the common law grew into use by gradual adoption and received from time to time the sanction of the courts of justice without any legislative act or interference. It was the application of the dictates of natural justice and of cultivated reason to particular cases. In the just language of Sir Matthew Hale, the common law of England is not the product of the wisdom of some one man or society of men in any one age, but of the wisdom, counsel, experience, and observation of many ages of wise and observing men. And his further remarks on this subject would be well worthy the consideration of those bold projectors who can think of striking off a perfect code of law at a single essay. Where the subject of any law is single, the prudence of one age may go far at one essay to provide a fit law. And yet, even in the wisest provisions of that kind, experience shows us that new and unthought of emergencies often happen that necessarily require new supplements, abatements, or explanations. But the body of laws that concern the common justice applicable to a great kingdom is vast and comprehensive, consists of infinite particulars, and must meet with various emergencies, and therefore requires much time and much experience, as well as much wisdom and prudence, successively to discover defects and inconveniences, and to apply apt supplements and remedies for them. and such are the common laws of England, namely the productions of much wisdom, time, and experience. But though the great body of the common law consists of a collection of principles to be found in the opinions of sages, or deduced from universal and immemorial usage, and receiving progressively the sanction of the courts, it is nevertheless true that the common law, as far as it is applicable to our situation and government, has been recognized and adopted as one entire system by the constitutions of Massachusetts, New York, New Jersey, and Maryland. It has been assumed by the courts of justice or declared by statute with the like modifications as the law of the land in every state. It was imported by our colonial ancestors as far as it was applicable, and was sanctioned by royal charters and colonial statutes. It is also the established doctrine that English statutes passed before the immigration of our ancestors, and applicable to our situation and an amendment of the law, constitute a part of the common law of this country. Force of adjudged cases. The best evidence of this common law is to be found in the decisions of the courts of justice contained in numerous volumes of reports, and in the treatises and digests of learned men, which have been multiplying from the earliest periods of the English history down to the present time. The reports of judicial decisions contain the most certain evidence and the most authoritative and precise application of the rules of common law. Adjudged cases become precedents for future cases resting upon analogous facts, and brought within the same reason, and the diligence of counsel and the labor of judges are constantly required in the study of the reports in order to understand accurately their import and the principles they establish. But to attain a competent knowledge of the common law in all its branches has now become a very serious undertaking, and it requires steady and lasting perseverance in consequence of the number of books which beset and encumber the path of the student. The grievance is constantly growing, for the number of periodical law reports and treatises which issue from the English and American press is continually increasing, and if we wish to receive assistance from the commercial system of other nations, and to become acquainted with the principles of the Roman law as received and adopted in continental Europe, we are still in greater danger of being confounded and of having our fortitude subdued by the immensity and variety of the labors of the civilians. It is necessary that the student should exercise much discretion and skill in the selection of the books which he is to peruse. To encounter the whole mass of law publications in succession, if practicable, would be a melancholy waste or misapplication of strength and time. Lord Bacon, in the aphorisms annexed to his treatise De Augmentis Scientiarum, speaks of the necessity of a revision and digest of the law in order to restore it to a sound and profitable state whenever there has arisen a vast accumulation of volumes, throwing the system into confusion and uncertainty. The evils resulting from the indigestible heap of laws and legal authorities are great and manifest. They destroy the certainty of the law and promote litigation, delay, and subtlety. The professors of the law cannot afford the expense and time necessary to collect and study the volumes, and they are obliged to rely too much on the second-hand authority of digest. Ipse advocatus cum tot libris per lege et vincere non possit compendia sectatar glossa fortasse alcia bona. The period of the present age and the cause of truth and justice require more simplicity in the system, and that the text authorities should be reduced within manageable limits. And a new digest of the whole body of the American common law upon the excellent model of Coleman's Digest, and executed by a like master artist, retaining what is applicable and rejecting everything that is obsolete and inapplicable to our institutions, would be an immense public blessing. A solemn decision upon a point of law arising in any given case becomes an authority in a like case, because it is the highest evidence which we can have of the law applicable to the subject, and the judges are bound to follow that decision so long as it stands unreversed, unless it can be shown that the law was misunderstood or misapplied in that particular case. If a decision has been made upon solemn argument and mature deliberation, the presumption is in favor of its correctness, and the community have a right to regard it as a just declaration or exposition of the law, and to regulate their actions and contracts by it. It would therefore be extremely inconvenient to the public if precedents were not duly regarded and pretty implicitly followed. It is by the notoriety and stability of such rules that professional men can give safe advice to those who consult them, and people in general can venture with confidence to buy and to trust and to deal with each other. If judicial decisions were to be lightly disregarded, we should disturb and unsettle the great landmarks of property. When a rule has been once deliberately adopted and declared, it ought not to be disturbed unless by a court of appeal or review, and never by the same court except for very cogent reasons and upon a clear manifestation of error. And if the practice were otherwise, it would be leaving us in a state of perplexing uncertainty as to the law. The language of Sir William Jones is exceedingly forcible on this point. No man, says he, who is not a lawyer would ever know how to act, and no man who is a lawyer would in many instances know what to advise unless courts were bound by authority, as firmly as the pagan deities were supposed to be bound by the decrees of fate. Throughout the whole period of the yearbooks, from the reign of Edward III to that of Henry VIII, the judges were incessantly urging the sacredness of precedents, and that a counselor was not to be heard who spoke against them, and that they ought to judge as the ancient sages taught. If we judge against former precedents, said J. Preost, it will be a bad example to the barristers and students at law, and they will not give any credit to the books or have any faith in them. So the Court of King's Bench observed in the time of James I that the point which had been often adjudged ought to rest in peace. The inviolability of precedents was thus indicated at a period which we have been accustomed to regard as the infancy of our law, with as much zeal and decision as at any subsequent period. But I wish not to be understood to press too strongly the doctrine of stare decisis when I recollect that there are 1,000 cases to be pointed out in the English and American books of reports which have been overruled, doubted, or limited in their application. It is probable that the records of many of the courts in this country are replete with hasty and crude decisions, and such cases ought to be examined without fear and revised without reluctance rather than to have the character of our law impaired and the beauty and harmony of the system destroyed by the perpetuity of error. Even a series of decisions are not always conclusive evidence of what is law, and the revision of a decision very often resolves itself into a mere question of expediency, depending upon the consideration of the importance of certainty in the rule and the extent of property to be affected by a change of it. Lord Mansfield frequently observed that the certainty of a rule was often of much more importance in mercantile cases than the reason of it, and that a settled rule ought to be observed for the sake of property. And yet perhaps no English judge ever made greater innovations and improvements in the law or felt himself less embarrassed with the disposition of the elder cases when they came in his way to impede the operation of his enlightened and cultivated judgment. His successor, Lord Kenyon, acted like a Roman dictator appointed to recall and reinvigorate the ancient discipline. He controlled or overruled several very important decisions of Lord Mansfield as dangerous inventions, and on the ground that they had departed from the precedents of former times and disturbed the landmarks of property and had unauthorizedly superadded equity powers to a court of law. It is my wish and my comfort, said the venerable judge, to stand super antiquus vias. I cannot legislate, but by my industry I can discover what our predecessors have done, and I will tread in their footsteps. The English courts seem now to consider it to be their duty to adhere to the authority of adjudged cases, when they have been so clearly and so often or so long established as to create a practical rule of property, notwithstanding they may feel the hardship or not perceive the reasonableness of the rule. There is great weight in the maxim of Lord Bacon, a, that optima est lex quae minime relinquit arbitrio judicius, optimus judice, qui minimum sibi. The great difficulty as to cases consists in making an accurate application of the general principle contained in them to new cases presenting a change of circumstances. If the analogy to be imperfect, the application may be erroneous. The expressions of every judge must also be taken with reference to the case on which he decides. We must look to the principle of the decision and not to the manner in which the case is argued upon the bench, otherwise the law will be thrown into extreme confusion. The exercise of sound judgment is as necessary in the use as diligence and learning are requisite in the pursuit of adjudged cases. Considering the influence of manners upon law and the force of opinion which is silently and almost insensibly controlling the course of business and the practice of the courts, it is impossible that the fabric of our jurisprudence should not exhibit deep traces of the progress of society as well as of the footsteps of time. The ancient reporters are going very fast, not only out of use, but out of date and almost out of recollection. The modern reports and the latest of the modern are the most useful because they contain the last, and it is to be presumed, the most correct exposition of the law, and the most judicious application of abstract and eternal principles of right to the refinements of property. They are likewise accompanied by illustrations best adapted to the inquisitive and cultivated reason of the present age. But the old reporters cannot be entirely neglected, and I shall devote the remainder of this lecture to a short historical review of the principal reporters prior to the present times. No one ought to read a book, said Monsieur Lamy, and the remark has peculiar application to law books, unless he knows something of the author and when he wrote, and the character of the work and the character of the edition. The division line between the ancient and the modern English reports may, for the sake of convenient arrangement, be placed at the Revolution in the year 1688. The distinction between the old and new law seems then to be more distinctly marked. The cumbersome and oppressive appendages of the feudal tenures were abolished in the reign of Charles II, and the spirit of modern improvement and of commercial policy began then to be more sensibly felt and more actively diffused. The appointment of that great and honest lawyer, Lord Holt, to the station of Chief Justice of the King's Bench gave a new tone and impulse to the vigor of the common law. The despotism of the Stuarts was abolished forever, and the civil and political liberties of the English nation were more explicitly acknowledged and defined at the accession of the House of Orange. The old reporters will include all the reports from the yearbook down to that period, and we will, in the first place, bestow upon those of them which are the most distinguished a cursory glance and rapid review. Yearbooks. The oldest reports extant on the English law are the yearbooks, which consist of 11 parts or volumes written in law French and extend from the beginning of the reign of Edward II to the latter end of the reign of Henry VIII, a period of about 200 years. There are a few broken cases which may be gleaned from the old abridgments, and particularly from Fitzherbert, which go back to the reign of Henry III. The yearbooks were first printed in the reign of James I and were again printed by subscription in 1679, but they have never been translated, and they are not worth the labor and expense either of a new edition or a translation. The substance of the yearbooks was afterwards included in the great abridgments of Statham, Fitzherbert, and Brooke, and those compilations superseded in a considerable degree the use of them. The yearbooks were very much occupied with discussions touching the forms of writs and the pleadings and practice and real actions, which have gone entirely out of use. In a late case in the CB, the judges spoke with some sharpness of reproof against going back to the yearbooks in search of a precedent in the case of levying a fine. The great authenticity and accuracy of the yearbooks arose from the manner in which they were composed. There were 4 reporters appointed to that duty, and they had a yearly stipend from the Crown, and they used to confer together, and the reports being settled by so many persons of approved diligence and learning deservedly carried great credit with them. But so great have been the changes since the feudal ages in the character of property, the business of civil life, and the practice of the courts, that the mass of curious learning and technical questions contained in the yearbooks has sunk into oblivion, and it will be no cause of regret if that learning be destined never to be reclaimed. The yearbooks have now become nearly obsolete, and they are valuable only to the antiquary and historian as a faithful portrait of ancient customs and manners. Dyer. The yearbooks ended in the reign of Henry VIII because persons were no longer appointed to the task of reporting with the allowance of a fixed salary. Private lawyers then undertook the business of reporting for their own use or for the purpose of publication. Many English lawyers have regretted that the practice of appointing public reporters with a stipulated compensation, as is now the American practice, was not continued, as it would have relieved the profession from many hasty and inaccurate reports, which have greatly increased the uncertainty of the law. The reports of Dyer relate to the reigns of Henry VIII, Edward VI, Mary, and Elizabeth. They have always been held in high estimation, for Dyer presided as Chief Justice in the CB for upwards of 20 years, and was distinguished for learning, ability, and firmness. His reports were afterwards enriched by marginal notes of Chief Justice Treby, and which are said by Mr. Justice Buller to be good law. The work was compiled in law French and published in an English translation in 1793 with the notes. Plowden. Plowden's Commentaries embraces the same period as the reports of Dyer. They bear as high a reputation for accuracy as any ancient book of reports, though Lord Coke said he had discovered 4 cases in Plowden which were erroneous. Plowden gives the pleadings in those cases which judgment was entered, and the arguments of counsel and the decisions on the bench very much at large. They were first published in 1578 and take originally, as he says, for his private use. But he took great pains in rendering his work accurate, and he reported nothing but what had been debated and decided upon demurrer or special verdict, and his reports were likewise submitted to the inspection of the sergeants and judges. The work is, therefore, distinguished for its authenticity and accuracy, and though not of so dramatic a character as much of the yearbooks, it is exceedingly interesting and instructive by the evidence it affords of the extensive learning, sound doctrine, and logical skill of the ancient English bar. Coke's Reports. Lord Coke's reports in 13 parts or volumes are confined to the reigns of Elizabeth and James, and deservedly stand at the head of the ancient reports as an immense repository of common law learning. The first 11 books of his reports contain about 500 cases and were published in his lifetime, and he took care to report and publish only what he calls leading cases and conducive to the public quiet. Lord Bacon said that had it not been for Sir Edward Coke's reports, the law in that age would have been almost like a ship without a ballast, and that though they had extrajudicial resolutions, they did not contain infinite good decisions. Much of the various and desultory learning in these reports is law to this day, and the most valuable of the cases reported have been selected and recommended to the attention of the American student by Professor Hoffman of the University of Maryland in his course of legal study. When these reports were published between 1600 and 1615, there were no other prior reports but the yearbooks Dyer and Plowden. Lord Coke said that he endeavored in his reports to avoid obscurity, ambiguity, and prolixity. It is singular that he should have so egregiously failed in his purpose. The want of methodical arrangement and lucid order is so manifest in his reports, and he abounds so greatly in extrajudicial dicta and collateral discussions that he is distinguished above most other reporters for the very defects he intended to avoid. It is often very difficult to separate the arguments of counsel from the reasons and decisions of the court, and to ascertain precisely the point adjudged. This probably gave occasion to Ireland and Manley's abridgment of Lord Coke's reports, in which they undertake to detach from the work all the collateral discussion and learning, and to give only the very substance and marrow of the reports. A work of this kind may be convenient in the hurry of research, but I believe no accurate lawyer would ever be content to repose himself upon such a barren account of a decision without looking into the reason and authorities on which it was founded. With all their defects, Lord Coke's reports are a standard work of that age, and they alone are sufficient to have discharged him from that great obligation of duty with which he said he was bound to his profession. When Coke's reports were first published, they gave much offense to King James, as containing many doctrines which were deemed too free and injurious to the prerogative of the crown, and the king commanded Lord Coke to strike out the offensive parts, and he also referred the work to his judges to be corrected. But Lord Coke was too independent in spirit, and he had too high a regard to truth and law to gratify the king on this subject, and he was, for this and other causes, removed from the office of Chief Justice of the KB. Hobart. Hobart's reports of cases in the time of James I were printed in 1646, and in a subsequent age they were revised and corrected by Lord Chancellor Nottingham. Like the reports of Lord Coke, they are defective in method and precision, and are replete with copious legal discussions. Hobart was Chief Justice of the CB and a great lawyer. Judge Jenkins, the contemporary of Coke and Hobart, has given us, in the preface to his reports, an exalted eulogy on those distinguished men, and the biographical sketch of their characters is peculiarly animated and lively. Jenkins compiled his reports, or sentries, as he quaintly terms them, during the tumult of the civil wars under Charles I and the Commonwealth, and they resemble more a digest of decisions after the manner of Fitzherbert and Brooke than regular reports of adjudged cases. From his intemperate language and hard fate, it is evident he was a zealous royalist and had provoked the resentment of his enemies. He composed his work, as he says, when he was broken with old age and confinement in prison, where his fellow subjects, grown wild with rage, had detained him for 15 years, and that he was surrounded with an odious multitude of barbarians. He renders a just tribute of veneration to the memory of Lord Coke and Lord Hobart as two men who had furnished surprising light to the professors of the law. They were judges of great authority and dignity, who, to the most accurate eloquence, joined a superlative knowledge of the laws and consummate integrity, and whose names, he said, would flourish as long as the laws and the kingdom should endure. Lord Hobart, as he continues to observe, was adorned with the brightest endowments and a piercing understanding, and he had always equity before his eyes. Lord Coke was a judge whom power could not break nor favor bend. He enjoyed the smiles and frowns of the court by turns, and possessed an immense fortune which he had honestly acquired. The only thing objected to him as a fault was that he was thought to go to great lengths with the Republican party, but he admits that he died in the highest estimation. End of section 37. Section 38 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of Reports of Judicial Decisions, Part 2. Croke. Croke's reports of decisions in the courts of law in the reigns of Elizabeth, James, and Charles are a work of credit and celebrity among the old reporters. They commence about the time that Dyer ended and were first published under the protectorate of Cromwell. From the character of the judge, his gravity, learning, diligence, and advantages, and from the precision and brevity of his cases, these reports have sustained their character in every succeeding age and are, to this day, familiarly referred to as an authentic depository of the rules of the common law. Yelverton. The reports of Yelverton are a small collection of select cases in the latter part of the reign of Elizabeth and the first 10 years of the reign of James. He was a judge of the C.B. and one of the most eminent lawyers of that age, and which was truly the Augustan age of the old common law learning. These reports have been lately recommended to the notice of the American lawyer by a new edition published in this country and enriched with copious, valuable, and accurate notes by Mr. Metcalfe. Saunders. In the reign of Charles II, the most distinguished of the reports are those of Chief Justice Saunders. They are confined to decisions in the KB for the space of 6 years, between the 18th and 24th years of the reign of Charles II, and contain the pleadings and entries in the cases decided, as well as the arguments of counsel and the judgment of the court. They are recommended for the accuracy of the entries and the concise, clear, and pointed method of decision, and are particularly valuable to the practicing lawyer as a book of precedents as well as of decisions. They have always been esteemed the most accurate and valuable reports of that age, and this is the character which has been repeatedly given of them by the judges in modern times. A new edition of these reports was published in 1799 by Serjeant Williams, with very copious notes, which in many instances are distinct and elaborate essays on the subjects of which they treat. Lord Eldon has said in reference to this edition that to any one in a judicial situation it would be sufficiently flattering to have it said of him that he was as good a common lawyer as Serjeant Williams, and that no man ever lived to whom the character of a great common lawyer more properly applied. I have no doubt of the merit of the edition and of the great learning of the editor. The authorities, new and old, applicable to the subject, are industriously collected and methodically arranged. But with all the praise justly due to the edition, it is liable to the great objection of making one of the old reporters the vehicle of voluminous dissertations. They introduce perplexity and confusion by their number and length. If such treatises were published by themselves, the student would know better where to find them. But when appended to a plain reporter, they seem to be out of place. Notes would appear to be more appropriate if they were confined simply and dryly to the illustration of the case in the text, and to show, by a reference to other decisions, how far it might still be regarded as an authority, and when and where it had been confirmed, or questioned, or extended, or restricted, or overruled. The convenience and economy of the profession would certainly be well consulted by this course. This edition of Saunders so far surpasses in extent and variety of learning the original work as to become a new work of itself, which might properly be denominated Williams's Notes, and the venerable simplicity of the reporter is obscured and lost in the commentaries of the annotator. Vaughan. The reports of Chief Justice Vaughan contain some very interesting cases. He was a grave and excellent judge, and his reports consist chiefly of his own arguments and opinions, delivered while he was Chief Justice, and they are distinguished for great variety of learning. The reports of Sir Thomas Jones, who has also Chief Justice in the reign of Charles II, of Sir Creswell Levens, who was a judge of the C.B., of Sir Geoffrey Palmer, who was Attorney General under Charles II, of Lord Chief Justice Pollifex, whose reports consist of cases argued by him while he was at the bar, and of Sir William Jones, who was for 22 years a judge, are all of them works of authority, though a considerable part of the discussions and decisions which they record ceases at this day to excite much attention, or to be very applicable to the new and varied course of human affairs. Value of the old reports. and indeed it may be here observed that a very large proportion of the matter contained in the old reporters prior to the English Revolution has become superseded and is now cast into the shade by the improvement of modern times, by the disuse of real actions and of the subtleties of special pleadings, by the cultivation of maritime jurisprudence, by the growing value and variety of personal contracts, by the spirit of commerce and the enlargement of equity jurisdiction, by the introduction of more liberal and enlightened views of justice and public policy, and, in short, by the study and influence of the civil law. In pursuing the old reports, we cannot be but struck with the long, laborious, and subtle arguments and the great delay which accompanied the investigation of points of law. Thus, for instance, the case of Stoll versus Zouch in Plowden was argued twice in the CB, and then twice in the Exchequer Chamber, before all the judges in England. Calvin's case in Coke was argued first at the bar of the KB by counsel, then in the Exchequer Chamber, first by counsel and then by all the judges. It was afterwards argued by counsel at 2 different times, and then by all the judges at the next term upon 4 different days, and at another term thereafter by all the judges on 4 different days. So again, in Manby and Richards versus Scott, in Levins, the case was argued at the bar 3 several times by distinct counsel each time, and afterwards by all the judges at the bench. It was quite common in former times to have a case spoken at 2 and 3 and 4 several times, and each time at a different term before judgment was rendered. In Lord Chief Justice Will's reports in the reign of George II, we find a case which was argued 5 times and at 5 distinct terms, and the judgment was not rendered until the space of 5 years had elapsed from the first argument. It was not until the time of Lord Mansfield that such repeated arguments were disused and great dispatch and unexampled facility and vigor given to the administration of justice. There were some advantages attending repeated discussions which served as a compensation for the delay and expense attending them. They tended to dissipate shadows and doubts and to unite the opinions on the bench and prevent that constant division among the judges which has much weakened the authority of some of our American courts. Modern reports. From the era of the English Revolution, the reports increase in value and importance, and they deal more in points of law applicable to the great change in property and the commerce and business of the present times. I shall not undertake to speak critically of the particular merits of the modern reports, for this would lead me into 2 extensive details. Those of Lord Raymond and Sergeant Salcott embrace the reigns of William and Mary and Queen Anne, and during that period Lord Chief Justice Holt gave luster to the jurisprudence of his country. The reports of Sir John Strange, of Lord Chief Baron Combs, of Lord Chief Justice Wills, and part of the reports of Sergeant Wilson occupy the reigns of George I and II, and they are all respectable, and the reports of Wills and Wilson in particular very accurate repositories of the judicial decisions of those reigns. The reports of Lord Raymond and of Sergeant Wilson are also peculiarly valuable to the pleader, for the many useful entries and forms of pleading which accompany the cases. From that period, the English reports are to be read and studied with profound attention. The reports of Burrough, Cowper, and Douglas contain the substance of Lord Mansfield's judicial decisions, and they are among the most interesting reports in the English law. All the courts of law at Westminster have been filled with very eminent men since the time of the accession of George III, and we need only refer to the term reports and to East and his successors as reporters to the King's Bench, and to Wilson, Henry Blackstone, Bosanquet, and Puller, Taunton, and their successors in the CB for views and sketches of the English law in its most correct and cultivated state. A still deeper interest must be felt by the American lawyer in the perusal of the judicial decisions of his own country. Our American reports contain an exposition of the common law as received and modified in reference to the genius of our institutions. By that law we are governed and protected, and it cannot but awaken a correspondent attachment. But I need not undertake the invidious task of selection and discrimination among the numerous volumes of the reports of American decisions. Their relative character must be familiar to the profession, and it will be sufficient to advise the student to examine thoroughly and to obtain the mastery of the principles of law, as expounded and declared by our more important tribunals, whether they be of federal or of state jurisdiction. We have hitherto confined our attention to the reports of cases in the courts of common law, but the system of equity is equally to be found embodied in the reports of adjudged cases, and the rules and usages of the Court of Chancery are as fixed as those which govern other tribunals. Chancery decisions. They have been regarded as a kind of secondary common law framed or promulgated by the Court of Chancery within the last 2 centuries. That court is as much bound as a court of law by a series of decisions applicable to the case and establishing a rule. It has no discretionary power over principles and established precedents, and Chancery has grown to be a jurisdiction of so much strict technical rule that it is said by a distinguished writer on equity doctrines that there are now many settled rules of equity which require to be moderated by the rules of good conscience as much as the most rigorous rules of law did before the chancellors interfered on equitable grounds. A court of equity becomes, in the lapse of time, by gradual and almost imperceptible degrees, a court of strict technical jurisprudence, like a court of law. The binding nature of precedents in a court of equity was felt and acknowledged by Lord Keeper Bridgeman in the reign of Charles II, and in the case of the Earl of Montague versus Lord Bath, soon after the Revolution, Lord Chief Justice Treby, who sat for the Lord Chancellor, declared that the Court of Chancery was limited by the precedents and practice of former times, and that it was dangerous to extend its authority further. At this day, justice is administered in a court of equity upon as fixed and certain principles as in a court of law, and Lord Eldon has secured to himself a title to the reverence of his countrymen, for resisting the temptation so often pressed upon him to make principles and precedents bend to the hardship of a particular case. In this country, it is at least as important as in any other that the administration of justice, both legal and equitable, should be stable and uniform, and especially if there be any weight in the opinion of an ancient English lawyer, that variety of judgments and novelty of opinions were the 2 plagues of a commonwealth. We have no reports of Chancery decisions until subsequent till the time of Lord Bacon. Anciently, the Court of Chancery administered justice according to what appeared to be the dictate of conscience as applied to the case, without any regard to law or rule, and great inconvenience and mischief must have been produced in the infancy of the court, by reason of the uncertainty and inconsistency of its decisions, flowing from the want of settled principles. The jurisdiction of the court was greatly enlarged in the time of Cardinal Wolsey, who was Chancellor under Henry VIII, and he maintained his equitable jurisdiction with a high hand and exercised his authority over everything which could be a subject of judicial inquiry, and decided with very little regard to the common law. This conduct in his judicial capacity was one of the grounds of accusation against him when he was impeached. Under his successor, Sir Thomas More, who was the first chancellor that ever had the requisite legal education, business rose again with rapidity, and to such extent as to require the assistance of a master of the rolls. He allowed injunctions so freely as to displease the common law judges, though he acted always with great ability and integrity. To show how wonderfully business in Chancery had increased by the time of Lord Bacon, we need only recur to the fact which he gives us himself, that he made 2,000 orders and decrees in a year, and yet we have not a single decision of his reported. Those decisions, if well and faithfully reported, would doubtless have presented to the world a clear illustration and masterly display of many principles of equity, since greatly considered and discussed. For even upon dry technical rules and points of law, he shed the illuminations of his mighty mind. In West's Symboliography, a work published at the close of Elizabeth's reign, we have divers curious and authentic precedents of the process and bills and answers in Chancery prior to the time of Bacon. We have also in the same work a brief digest of the powers and jurisdiction of the court, from which it would appear that equity was regarded in that day as a matter of arbitrary conscience, unencumbered by any rules or principles of law. No cases are cited to show what the authority was, but such as were gleaned from the yearbooks and the treatise of the doctor and student and of the diversity of courts. Earliest Chancery reports. It was not until after the Restoration that any reports of adjudged cases in Chancery were published. The volumes entitled Reports of Cases Taken and Adjudged in the Court of Chancery in the reigns of Charles I, Charles II, James II, William III, and Queen Anne, commence with the reign of Charles I and contain the earliest adjudged cases in equity. But that work and another contemporary work of the same character entitled Cases Argued and Adjudged in the High Court of Chancery are both of them, in their general character, loose, meager, and inaccurate reports of not much weight or authority. The reports of some cases decided by Lord Chancellor Cowper in the third and last volume of the Reports in Chancery, and the great case of the Duke of Norfolk, and the case of Bath and Montague at the conclusion of the cases in Chancery, are distinguished exceptions to this complaint, and those great cases are fully and very interestingly reported. In the latter part of the reign of Charles II, Lord Chancellor Nottingham raised the character of the court to high reputation, and established both its jurisprudence and its jurisdiction upon wide and rational foundations. We have but few reports of his decisions that are worthy of his fame. They are dispersed through several works of inferior authority. It is from his time, however, that equity became a regular and cultivated science, and the judicial decisions in Chancery are to be carefully studied. Vernon. Vernon's reports are the best of the old reports in Chancery. They were published from his manuscripts after his death by order of Chancellor King, and were found to be quite imperfect and inaccurate. In 1806, Mr. Rathby favored the profession with a new and excellent edition of Vernon, enriched by learned notes and accurate extracts from the register's books, so that the volumes assumed a new dress and more unquestionable authenticity. Those reports include part of the judicial administration of Lord Nottingham and the whole of the time of Lord Somers, but they give us nothing equal to the reputation of those great men. They bring the series of equity decisions down to the conclusion of Lord Chancellor Cowper's judicial life. Precedents in Chancery. Precedents in Chancery is a collection of cases between 1689 and 1722, and the author of those reports and of the first volume of Equity Cases Abridged is generally supposed to be the same person. They are works which contain very brief cases in comparison with the voluminous details of modern reports, but they are of respectable authority. Peer Williams. Peer Williams's reports extend from the beginning of the last century to the year 1735, and they embrace the period of the decisions of a succession of eminent men who presided in Chancery in the former part of that century. The notes of Mr. Cox to the fourth edition of these reports gave to that edition the character of being the best edited book on the law. Even before his learning and industry had given new character and value to the reports of Peer Williams, they were regarded as one of the most perspicuous, useful, and interesting repositories of equity law to be found in the language. Moseley. Moseley's reports of cases during the time of Lord King have received a various and contradictory character and treatment. Lord Mansfield said it was a book not to be quoted, but Lord Eldon, who is presumed to have been a better judge of the merits of the work, says that Moseley is a book of considerable accuracy. It is fortunate that we have even so imperfect a view of the decisions of Lord King, who was an eminent scholar, and to whom Mr. Locke bequeathed his papers and library. Talbot. Lord Talbot presided in Chancery but a very few years. He was a pure and exalted character who died in the vigor of his age, and his loss was lamented as a great national calamity. The cases during his time, under the title of Cases Temporo Talbot, are well reported and have a reputation for accuracy. Lord Hardwicke, the successor of Lord Talbot, held the Great Seal for upwards of 20 years, and the present wise and rational system of English equity jurisprudence owes more to him than perhaps to any of his predecessors. Vesey and Atkins. Vesey and Atkins. His decisions are reported in the elder Vesey and Atkins and partly in Ambler and Dickens, and though none of them are eminent reporters either for accuracy or precision in the statements of the cases, or in giving the judgment of court, yet the value of his opinions and the great extent of his learning and the solidity of his judgment have been sufficiently perceived and understood. There is no judge in the judicial annals of England whose judicial character has received greater and more constant homage. His knowledge of the law, said a very competent judge, was most extraordinary, and he was a consummate master of the profession. His decisions at this day and in our own courts do undoubtedly carry with them a more commanding weight of authority than those of any other judge, and the best editions of the elder Vesey and Atkins will continue to fix the attention and study of succeeding ages. Eden. Eden's reports of the decisions of Lord Northington, the successor to Lord Hardwicke, are very authentic and highly esteemed. They surpass in accuracy the reports either of Ambler or Dickens within the same period, and the authority of Lord Northington is very great, and it arose from the uncommon vigor and clearness of his understanding. Brown. The next book of reports of deserved celebrity is Brown, commencing with Lord Thurlow's appointment to the office of Chancellor, and the high character of the court at that period gave to those reports a very extensive authority and circulation, and for which they were indebted more to the reputation of the Chancellor than to any merit in the execution of the work. Cox. Cox's cases in Chancery give us the decisions of Lord Kenyon while he was Master of the Rolls under Thurlow, as well as the decisions of the Lord Chancellor during the same period. They were intended as a supplement to the reports of Brown and the younger Vesey, so far as those reports covered the period embraced by the cases, and they are neat, brief, and perspicuous reports of unquestionable accuracy. A new and greatly improved edition has lately been published in New York under the superintendence of one of the masters in Chancery. Younger Vesey. The reports of the younger Vesey extend over a large space of time and contain the researches of Sir Richard Pepper Arden as Master of the Rolls, and the whole of the decisions of Lord Loughborough, and carry us far into the time of Lord Eldon. These reports are distinguished for their copiousness and fidelity. The same character is due the reports of his successors, and though great complaints have been made at the delay of causes arising from the cautious and doubting mind of the present venerable Lord Chancellor of England, it seems to be universally conceded that he bestows extraordinary diligence in the investigation of immense details of business, and arrives in the end at a correct conclusion, and displays a most comprehensive and familiar acquaintance with equity principles. It must nevertheless be admitted that the reports of Lord Eldon's administration in equity, amounting to perhaps 30 volumes, and replete with attenuated discussion and loose suggestions of doubts and difficulties, are enough to task very severely the patience of the profession. There are recent reports of decisions in other departments of equity which are deserving of great attention. The character of those branches of the equity jurisdiction is eminently sustained, and the reported decisions of Lord Redesdale and Lord Manners in the Irish Court of Chancery are also to be placed on a level in point of authority with the best productions of the English bench. Upon our American equity reports I have only to observe that being decisions in cases arising under our domestic laws and systems, they cannot but excite a stronger interest in the mind of the student, and from their more entire application to our circumstances, they will carry with them the greater authority. General merit of reports. I have now finished a succinct detail of the principal reporters, and when the student has been thoroughly initiated in the elements of legal science, I would strongly recommend them to his notice. The old cases prior to the year 1688 need only be occasionally consulted, and the leading decisions in them examined. Some of them, however, are to be deeply explored and studied, and particularly those cases and decisions which have spread their influence far and wide, and established principles which lie at the foundations of English jurisprudence. Such cases have stood the scrutiny of contemporary judges and been illustrated by succeeding artists, and are destined to guide and control the most distant posterity. The reports of cases since the middle of the last century ought in most instances to be read in course, and they will conduct the student over an immense field of forensic discussion. They contain that great body of the commercial law and of the law of contracts, and of trusts which governs at this day. They are worthy of being studied even by scholars of taste and general literature, as being authentic memorials of the business and manners of the age in which they were composed. Law reports are dramatic in their plan and structure. They abound in pathetic incident and displays of deep feeling. They are faithful records of those little competitions, factions, and debates of mankind that fill up the principal drama of human life. For wealth, the allurements of pleasure, the delusions of self-interest, the melancholy perversion of talent, and the machinations of fraud. They give us the skillful debates at the bar and the elaborate opinions on the bench, delivered with the authority of oracular wisdom. They become deeply interesting because they contain true portraits of the talents and learning of the sages of the law. We should have known but very little of the great mind and varied accomplishments of Lord Mansfield if we had not been possessed of the faithful reports of his decisions. It is there that his title to the character of founder of the commercial law of England is verified. A like value may be attributed to the reports of the decisions of Holt, Hardwicke, Wills, Wilmot, de Grey, Camden, Thurlow, Kenyon, Sir William Scott, and many other illustrious names, which will be as immortal as the English law. Nor is it to be overlooked as a matter of minor importance that the judicial tribunals have been almost uniformly distinguished for their immaculate purity. Every person well acquainted with the contents of the English reports must have been struck with the unbending integrity and lofty morals with which the courts were inspired. I do not know where we could resort among all the volumes of human composition to find more constant, more tranquil, and more sublime manifestations of the intrepidity of conscious rectitude. If we were to go back to the iron times of the Tudors and follow judicial history down from the first page in Dyer to the last page of the last reporter, we should find the higher courts of civil judicature, generally and with rare exceptions, presenting the image of the sanctity of a temple where truth and justice seem to be enthroned and to be personified in their decrees. End of section 38. Section 39 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of the Principal Publications of the Common Law. Lecture 22. The reports of adjudged cases are admitted to contain the highest and most authentic evidence of the principles and rules of the common law. But there are numerous other works of sages in the profession which contribute very essentially to facilitate the researches and abridge the labor of the student. Those works acquire by time and their intrinsic value the weight of authority, and the earlier textbooks are cited and relied upon as such in the discussions at the bar and upon the bench in cases where judicial authority is wanting. Glanville. One of the oldest of these treatises is Glanville's Tractatus de Legibus Angelis, composed in the reign of Henry II. It is a plain, dry, perspicuous essay on the ancient actions and the forms of writs then in use. It has become almost obsolete and useless for any practical purpose owing to the disuse of the ancient actions, but it is a curious monument of the improved state of the Norman administrations of justice. It is peculiarly venerable if it be, as it is said, the most ancient book extant upon the laws and customs of England. It has been cited and commented upon and extolled by Lord Coke, Sir Matthew Hale, Sir Henry Spelman, Selden, Blackstone, and most of the eminent lawyers and antiquaries of the last 2 centuries. Mr. Reeves says that he incorporated the whole of Glanville into his history of the English law. Bracton. Bracton wrote his treatise De Legibus et Consuetudinibus Angelique in the reign of Henry III, and he is said to have been a judge itinerant in that reign and professor of law at Oxford. He is a classical writer and has been called by a perfect judge of his merits, the father of the English law, and the great ornament of the age in which he lived. His work is a systematic performance, giving a complete view of the law in all its titles as it stood at the time it was written, and it is filled with a copious and accurate detail of legal learning. It treats of the several ways of acquiring, maintaining, and recovering property, much in the manner of the Institutes of Justinian. The style is clear and expressive and sometimes polished, and it has been imputed to the influence of the civil and canon law, which he had studied and admired, and the work evinces by the freedom of the quotations that he had drank deep at those fountains. Sir William Jones says he is certainly the best of our juridical classics, though he is perfectly aware that Bracton copied Justinian almost word for word. In the reign of Edward I, Bracton was reduced into a compendium by Thornton, which shows, says Selden, how great the authority of Bracton was in the time of Edward I. He continued to be the repository of ancient English jurisprudence and the principal source of legal authority down to the time of the publication of the Institutes of Lord Coke. Stanford, in his Pleas of the Crown, published about the time of Philip and Mary, bears strong testimony to the merits and to the authority of Bracton. It is stated in Plowden that neither Glanville nor Bracton were to be cited as authorities, but rather as ornaments to the discourse, and in several other books the same thing was said. But Mr. Reeve, in his History of the English Law, justly vindicates the character of Bracton from such unmerited aspersion, and what is as much and perhaps more to the purpose, the learned Selden, whose knowledge of English legal antiquities was unrivalled, declares that this notion is founded in error. Glanville and Bracton are authors of great service to all who apply themselves to the study of the law and are desirous of knowing its origin and progress from the very foundation. They contain numberless things, said Selden, which in his day either remained entire or were only partially abrogated, and they contain such information on ancient customs and laws as to carry with them authority as well as illustration. Lord Holt, in the great case of Coggs versus Bernard, made free use of Bracton and spoke of him as an old author full of reason and good sense. Britain and Fleta. Britain and Fleta, two treatises in the reign of Edward I, were nothing more than appendages to Bracton, and from which they drew largely. Lord Coke says that Britain was Bishop of Hereford and of profound judgment in the common law, and that Fleta was written by some learned lawyer while in confinement in the Fleet prison. The dissertation which Selden annexed to the edition of Fleta, printed in his time, is evidence of the high estimation in which the work was then held, and it is a little singular that President Henault, in his chronological abridgment of the history of France, should refer to this ancient English treatise of Fleta as a historical authority. Sir John Fortescue. Sir John Fortescue's treatise De Laudibus Legum Angelici was written in the reign of Henry VI, under whom he was Chief Justice and afterwards Chancellor. It is in the form of a dialogue between him and the young prince, and he undertakes to show that the common law was the most reasonable and the most ancient in Europe, and superior to the civil law. It displays sentiments of liberty and a sense of a limited monarchy remarkable in the fierce and barbarous period of the Lancastrian civil wars, and an air of probity and piety runs through the work. He insisted, for instance, that the conviction of criminals by juries and without torture was much more just and humane than the method of the continental nations, and that the privilege of challenging jurors and of bringing writs of attaint upon corrupt verdicts and the usual wealth of jurors afforded that security to the lives and property of English subjects which no other country was capable of affording. He run a parallel in many instances between the common and the civil law in order to show the superior equity of the former, and that the proceedings in courts of justice were not so dilatory as in other nations. Though some of the instances of that superiority which he adduces, such as the illegitimacy of antinuptial children and the doctrine of feudal wardships, are of no consequence, yet the security arising from trial by jury and the security of life and property by means of the mixed government of England and the limitations of the royal prerogative were solid and preeminent marks of superiority. This interesting work of Fortescue has been translated from the Latin into English and illustrated with the notes of the learned Selden, and it was strongly recommended in a subsequent age by such writers as Sir Walter Raleigh and St. Germain. And while upon this author we cannot but pause and admire a system of jurisprudence, which in so uncultivated a period of society contained such singular and invaluable provisions in favor of life, liberty, and property, as those to which Fortescue referred. They were unprecedented in all Greek and Roman antiquity, and being preserved in some tolerable degree of freshness and vigor, amidst the profound ignorance and licentious spirit of the feudal ages, they justly entitle the common law to a share of that constant and vivid eulogy which the English lawyers have always liberally bestowed upon their municipal institutions. Littleton. Littleton's Book of Tenures was composed in the reign of Edward IV, and it is confined entirely to the doctrines of the Old English law concerning the tenure of real estates and the incidents and services relating thereto. In the first book, Littleton treats of the quantity of interest in estates under the head of fee simply, fee tail, tenant in dower, tenant by the courtesy, tenant for life, for years, and at will. In the second book, he treats of the several tenures and services by which lands were then held, such as homage, fealty, villanage, and knight service. In the third book, he treats of divers subjects relative to estates and their tenures under the heads of parsoners, joint tenants, estates on condition, releases, warranty, etc. He explained the learning of that period on the subject of tenures and estates with a felicity of arrangement and perspicuity and precision of style that placed him above all other writers on the law. No work ever attained a more decided and permanent reputation for accuracy and authority. Lord Coke says that Littleton's Tenures was the most perfect and absolute work and as free from error as any book that ever was written on any human science, and he is justly indignant at the presumptuous and absurd censures which the celebrated civilian Hopman was pleased to bestow on Littleton's clear and accurate view of English feudal tenures. He said he had known many of his cases drawn in question, but never could find any judgment giving against any of them which could not be affirmed of any other book in our law. The great excellence of Littleton in his full knowledge of the subject and the neatness and simplicity of his manner. He cites but very few cases, but he holds no opinion, says his great commentator, but what is supported by authority and reason. A great part of Littleton is not now law or is entirely obsolete with us, and particularly much of the matter in the chapters on estates and fetail, copyholds, feudal services, discontinuance, attornment, remitter, confirmation, and warranty. But, even at this day, what remains concerning tenures cannot be well understood without a general knowledge of what is abolished, and even the obsolete part of Littleton can be studied with pleasure and profit by all who are desirous to trace the history and grounds of the law. It has been supposed by Mr. Butler that Littleton's treatise would still be a proper introduction to the institutes of the English law on the subject of real estates. Perkins' Treatise of the Laws of England, written in the reign of Henry VIII, has always been deemed a valuable book for the learning and ingenuity displayed in it relating to the title and conveyance of real property. Coke said it was wittily and learnedly composed, and Lord Mansfield held it to be a good authority in point of law. It treats of grants, deeds, feoffments, exchange, dower, courtesy, devices, surrenders, reservations, and conditions, and it abounds with citations and supports the positions laid down by references to the yearbooks and Fitzherbert's abridgment. Doctor and Student. The dialogue between a doctor of divinity and a student in law was written by St. Germain in the reign of Henry VIII, and discusses in a popular manner many principles and points of common law. The 17th edition of this work was published in 1787 and dedicated to the younger students and professors of law. It has always been considered by the courts and the best of the juridical writers as a book of merit and authority. The form of writing by dialogue was much in use among the ancients, and some of the finest treatises of the Greeks and Romans were written in that form, and particularly the remains of the Socratic school and the writings of Xenophon and Plato, and the rhetorical and philosophical treatise of Cicero. The three most interesting productions in the form of dialogue on the English law are Fortescue, already mentioned, this work of St. Germain, and the elegant and classical work entitled Eumenes, or Dialogues Concerning the Law and Constitution of England by Mr. Wynne. Lord Bacon. But the legal productions of the preceding ages were all surpassed in value and extent in the reigns of Elizabeth and James by the results of the splendid talents and immense erudition of Bacon and Coke. The writings of Lord Bacon on the municipal law of England are not to be compared in reputation to his productions in metaphysical and moral science, but it is nevertheless true that he shed light and learning and left the impression of profound and original thought on every subject which he touched. It was the course of his life to connect law with other studies, and therefore he admitted that his arguments might have the more variety and perhaps the greater depth of reason. His principal law tracts are his Elements of the Common Law, containing an illustration of the most important maxims of the common law and of the use of the law in its application to the protection of person, property, character, and his reading upon the Statute of Uses. Lord Bacon seems to have disdained to cite authorities in his law treatise, and in that respect he approved of the method of Littleton and Fitzherbert and condemned that of Perkins and Staunford. He admits, however, that in his own private copy he had all his authorities quoted, and that he did sometimes weigh down authorities by evidence of reason, and that he intended rather to correct the law than soothe received error, or endeavor to reconcile contradictions by unprofitable subtlety. He made a proposal to King James for a digest of the whole body of the common and statute law of England, and if he had been encouraged and enabled to employ the resources of his great mind on such a noble work, he would have done infinite service to mankind and have settled in his favor the question, which he said would be made with posterity, whether he or Coke was the greater lawyer. The writings of Lord Bacon are distinguished for the perspicuity and simplicity with which every subject is treated. Coke's Institutes. Lord Coke's Institutes have had a most extensive and permanent influence on the common law of England. The first part is a commentary upon Littleton's tenures, and notwithstanding the magnitude of the work, it has reached 17 editions. Many of the doctrines which his writings explain and illustrate have become obsolete, or have been swept away by the current of events. The influence of 2 centuries must inevitably work a great revolution in the laws and usages, as well as in the manners and taste of a nation. Perhaps everything useful in the Institutes of Coke may be found more methodically arranged and more interestingly taught in the modern compilations and digests, yet his authority on all subjects connected with the ancient law is too great and too venerable to be neglected. The writings of Coke, as Butler has observed, stand between and connect the ancient and the modern law, the old and the new jurisprudence. He explains the ancient system of law as it stood in his day, and he points out the leading circumstances of the innovation which was begun. We have in his works the beginning of the disuse of real actions, the tendency of the nation to abolish the military tenures, the rise of a system of equity jurisdiction, and the outlines of every point of a modern law. The second part of the Institutes of Coke is a commentary upon the ancient statutes, beginning with Magna Carta and proceeding down to the reign of Henry VIII, and his commentaries upon the ancient statutes consisted, as he himself declared, of the authentic resolutions of the courts of justice, and were not like the glosses of the civilians upon the text of the civil law, which contained so many diversities of opinion as to increase rather than to resolve doubts and uncertainties. His commentary upon Magna Carta, and particularly on the celebrated 29th chapter, is deeply interesting to the lawyers of the present age, as well as from the value and dignity of the text as the spirit of justice and of civil liberty which pervades and animates the work. In this respect, Lord Coke eclipses his contemporary and great rival, Lord Bacon, who was as inferior to Coke in a just sense and manly vindication of the freedom and privileges of the subject, as he was superior in general science and philosophy. Lord Coke, in a very advanced age, took a principal share in proposing and framing the celebrated Petition of Right, containing a parliamentary sanction of those constitutional limitations upon the royal prerogative, which were deemed essential to the liberties of the nation. The third and fourth parts of the Institutes treat of high treason and the other pleas of the crown, and the history and antiquities of the English courts. The harshness and severity of the ancient criminal code of England are not suited to the taste and moral sense of the present age, and those parts of the Institutes are of very inconsiderable value and use, except it be to enlighten the researches of the legal antiquary. In this respect, Coke's pleas of the crown are inferior to the work under that title by Stanford, who wrote in the age of Philip and Mary, and was the earliest writer who treated didactically on that subject. Stanford wrote in law French, but Lord Coke more wisely and benevolently wrote in English because he said the matter of which he treated concerned all the subjects of the realm. Statum. Before we quit the period of the Old Law, we must not omit to notice the grand abridgments of Statum, Fitzherbert, and Brooke. Statum was a baron of the Exchequer in the time of Edward IV. His abridgment of the law was a digest of most titles of the law, and comprising under each head adjudged cases from the year books given, in a concise manner. The cases were strung together without regard to connection of matter. It is doubtful whether it was printed before or after Fitzherbert's work, but the latter entirely superseded it. Fitzherbert. Fitzherbert was published in the reign of Henry VIII and came out in 1514 and was a work for that period of singular learning and utility. Brooke. Brooke was published in 1573 and in a great degree superseded the others. The two last abridgments contain the substance of the year-books regularly digested, and by the form and order which they gave to the rude materials before them and the great facility which they afforded to the acquisition of knowledge, they must have contributed very greatly and rapidly to the improvement of legal science. Even those exceedingly laborious abridgments were in their turn to be superseded by the abridgments of Roll and his successors. Cowell. Dr. Cowell, who was contemporary with Coke, published in Latin an Institute of the Laws of England after the manner of Justinian's Institutes. His work was founded upon the old feudal tenures, such as the law of wards and liveries, tenure in capite, and knight service. While the writings of Lord Coke have descended with fame and honor to posterity, it was the fate of the learned labors of Dr. Cowell to pass unheeded and unknown into irreclaimable oblivion. Reeve. And with respect to all the preceding periods, Reeve's History of the English Law contains the best account that we have of the progress of the law, from the time of the Saxons to the reign of Elizabeth. It covers the whole ground of the law included in the old abridgments, and it is a work deserving of the highest commendation. I am at a loss which most to admire the full and accurate learning which it contains, or the neat, perspicuous, and sometimes elegant style in which that learning is conveyed. Finch's Discourse. The treatise of Sir Henry Finch, being a discourse in 4 books on the maxims and positive grounds of the law, was first published in French in 1613, and we have the authority of Sir William Blackstone for saying that his method was greatly superior to that in all the treatises that were then extant. His text was weighty, concise, and nervous, and his illustrations apposite, clear, and authentic. But the abolition of the feudal tenures and the disuse of real actions have rendered half of his work obsolete. Shepherd's Touchstone. Shepherd's Touchstone of Common Assurances was a production of Mr. Justice Doddridge in the reign of James I. It is a work of great value and authority, touching the common law modes of conveyance and those derived from the Statute of Uses. It treats also copiously of the law of uses and devices, but the great defect of the book is the want of that lucid order and perspicuous method which are essential to that cheerful perusal and ready perception of the merits of such a work. The second volume of Collectanea Juridicia has an analysis of the theory and practice of conveyancing, which is only a compendious abridgment of the Touchstone, and there is a very improved edition of it by Preston, who has favored the profession with several excellent tracts on the law of real property. Roll's Abridgment. Roll's Abridgment of the Law was published soon after the Restoration with an interesting preface by Sir Matthew Hale. It brings down the law to the end of the reign of Charles I, and though it be an excellent work and in point of method, succinctness, and legal precision, a model of a good abridgment, Sir Matthew Hale considered it an unequal monument of the fame of Roll, and that it fell short of what might have been expected from his abilities and great merit. It is also deemed by Mr. Hargrave a great defect in Viner's very extensive abridgment, that he should have attempted to engraft it on such a narrow foundation as that of Roll's work. Roll was Chief Justice of England under the Protectorate of Cromwell and under the preceding Commonwealth, but as his abridgment was printed in the reign of Charles II, he has no other title annexed to his name than that of Sergeant Roll, and his republican dignity was not recognized. Since the period of the English Revolution, the new digests have superseded the use of the former ones, and Bacon, Viner, Combes, and Crews contain such a vast accession of modern law learning that their predecessors have fallen into oblivion. Viner's abridgment, with all its defects and inaccuracies, is a convenient part of every lawyer's library. We obtain by it an easy and prompt access to the learning of the yearbooks and the old abridgments, and the work is enriched with many reports of adjudged cases not to be found elsewhere. But after all that can be said in its favor, it is an enormous mass of crude, undigested matter, and not worth the labor of the compilation. Comon's Digest. The Digest of Lord Chief Baron Comons is a production of vastly higher order and reputation, and it is the best digest extant upon the entire body of the English law. Lord Kenyon held his opinion alone to be of great authority, for he was considered by his contemporaries as the most able lawyer in Westminster Hall. The title pleader has often been considered as the most elaborate and useful head of the work, but the whole is distinguished for the variety of the matter, its lucid order, the precision and brevity of the expression, and the accuracy and felicity of the execution. Bacon's Abridgment. Bacon's abridgment was composed chiefly from materials left by Lord Chief Baron Gilbert. It has more of the character of an elementary work than Comon's Digest. The first edition appeared in 1736 and was much admired, and the abridgment has maintained its great influence down to the present time as being a very convenient and valuable collection of principles, arising under the various titles in the immense system of the English law. Cruse's Digest. And in connection with this branch of the subject, it will be most convenient, though a little out of the order of time, to take notice of Cruse's recent and very valuable Digest of the Laws of England respecting real property. It is by far the most perfect elementary work of the kind which we have on the doctrine of real property, and it is distinguished for its methodical, accurate, perspicuous, and comprehensive view of the subject. All his principles are supported and illustrated by the most judicious selection of adjudged cases. They are arranged with great skill and applied in confirmation of his doctrines with the utmost pertinency and force. Baron Gilbert. The various treatises of Lord Chief Baron Gilbert are of high value and character, and they contributed much to advance the science of law in the former part of the last century. His treatise on tenures deserves particular notice, as having explained upon feudal principles several of the leading doctrines in Littleton and Coke, and it is a very elementary and instructive essay upon that abstruse branch of learning. His essay on the law of evidence is an excellent performance and the groundwork of all the subsequent collections on that subject, and it still maintains its character, notwithstanding the law of evidence, like most other branches of the law, and particularly the law of commercial contracts, has expanded with the progress and exigencies of society. His treatise on the law of uses and trusts is another work of high authority, and it has been rendered peculiarly valuable by the revision and copious notes of Mr. Sugden. Hale and Hawkins. The treatises on the pleas of the Crown by Sir Matthew Hale and Sergeant Hawkins appeared early in the last century, and they contribute to give precision and certainty to that most deeply interesting part of jurisprudence. They are both of them works of authority and have had great sanction and been uniformly and strongly recommended to the profession. Sir Martin Wright. Sir Martin Wright's Introduction to the Law of Tenures is an excellent work, and the value of it cannot be better recommended than by the fact that Sir William Blackstone has interwoven the substance of that treatise into the second volume of his Commentaries. Dr. Wood published in 1722 his Institute of the Laws of England. His object was to digest the law and to bring it into better order and system. By the year 1754, his work had passed through 8 folio editions, and thereby afforded a decisive proof of its value and popularity. It was greatly esteemed by the lawyers of that age, and an American judge, himself a learned lawyer of the old school, has spoken of Wood as a great authority and of weight and respect in Westminster Hall. Blackstone. But it was the fate of Wood's institutes to be entirely superseded by more enlarged, more critical, and more attractive publications, and especially by the commentaries of Sir William Blackstone, who is justly placed at the head of all the modern writers who treat of the general elementary principles of the law. By the excellence of his arrangement, the variety of his learning, the justness of his taste, and the purity and elegance of his style, he communicated to those subjects which were harsh and forbidding in the pages of Coke the attractions of a liberal science and the embellishments of polite literature. The second and third volumes of the Commentaries are to be thoroughly studied and accurately understood. What is obsolete is necessary to illustrate that which remains in use, and the greater part of the matter in those volumes is law at this day and on this side of the Atlantic. I have necessarily been obliged to omit the mention of many valuable works upon law, as my object in the present lecture was merely to select those which were the most useful or distinguished. Modern treatises. With respect to the modern didactic treatises on various heads of the law, and which have multiplied exceedingly within the period of the present generation, I can only take notice of a few of those which relate to the law of real property, and are deemed the most important. The numerous works, both foreign and domestic, on various branches of the law of personal rights and commercial contracts, I may have occasion to refer to hereafter, as the subjects of which they treat pass under consideration in the course of these lectures. Any critical notice of them at present would lead us too far from the general purpose of this inquiry, and many of them are not sufficiently matured by time to become of much authority. Sanders's essay on the uses and trusts is a comprehensive and systematic treatise, but it wants that fullness of illustration and neat and orderly arrangement requisite in the discussion of so abstruse and complicated a branch of the law. The learned Mr. Butler has given a very elaborate note on the same subject. and there is an excellent summary of the law of uses and trusts in Cruse's Digest, arranged with his customary skill and supported by an accurate analysis of adjudged cases, which are apposite and pertinent to the inquiry. Sugden's Practical Treatise on Powers is the best book we have on that very abstruse title in the law. It was regarded by the author as his favorite performance, and he is entitled to the gratitude of the student for his masterly execution of the work. It is perspicuous, methodical, and accurate. Mr. Sugden's treatise on the law of vendors and purchasers is also a correct and useful collection of equity principles on a subject extremely interesting and of constant forensic discussion. Roberts on fraudulent conveyances covers a very important head in the jurisprudence of the courts of equity. He has collected the cases arising under the statutes of 13 and 27 Elizabeth respecting conveyances that are deemed fraudulent in respect to creditors and purchasers. And though the treatise is written in bad taste, it is a useful digest of the law on that subject. Powell's essay upon the learning of devices containing a systematical and valuable view of an important branch of the law concerning title to real property, and it is enlivened with some spirited discussions. But neither that essay nor the one of his upon mortgages are to be compared to the clear, succinct, and masterly analysis of the cases under similar titles in the great work of Mr. Cruse Fearn's Essay on Contingent Remainders and Executory Devices is a performance of a very superior character. It is eminently distinguished for the ability and perspicuity with which it unfolds and explains the principles of the most intricate parts of the law. Mr. Preston's recent Essays on Estates and Abstracts of Title contain sound and clear views of the law of real property, and they have already attained the authority of works of established reputation. I have thus attempted, for the assistance of the student, to unfold in this and the preceding lecture the principal sources from which we derive the evidence and rules of the common law. There is another source still untouched from which a great accession of sound principles, particularly on the subject of personal contracts, has been received to enlarge, improvement, and adorn our municipal codes. I allude to the body of the civil law contained in the Institute's Digest and Code of Justinian, and our attention will be directed to that subject in the next lecture. End of section 39. Section 40 of Commentaries on American Law, Volume 1. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. Commentaries on American Law, Volume 1 by James Kent. Of the Civil Law. Lecture 23. The great body of the Roman or civil law was collected and digested by order of the Emperor Justinian in the former part of the 6th century. That compilation has come down to modern times, and the institutions of every part of Europe have felt its influence, and it has contributed largely by the richness of its materials to their character and improvement. With most of the European nations and in the new states in Spanish America, in the province of Lower Canada, and in one of these United States, it constitutes the principal basis of their unwritten or common law. It exerts a very considerable influence upon our own municipal law, and particularly on those branches of it which are of equity and admiralty jurisdiction, or fall within the cognizance of the surrogates or consistorial courts. The history of the venerable system of the civil law is peculiarly interesting. It was created and gradually matured on the banks of the Tiber by the successive wisdom of Roman statesmen, magistrates, and sages. And after governing the greatest people in the ancient world for the space of 13 or 14 centuries, and undergoing extraordinary vicissitudes after the fall of the Western Empire, it was revived, admired, and studied in modern Europe on account of the variety and excellence of its general principles. It is now taught and obeyed not only in France, Spain, Germany, Holland, and Scotland, but in the islands of the Indian Ocean and on the banks of the Mississippi and the St. Lawrence. So true, it seems, are the words of Jddykst, that the grand destinies of Rome are not yet accomplished. She reigns throughout the world by her reason, after having ceased to reign by her authority. My design in the present lecture is to make a few general observations on the history and character of the civil law, in order to excite the curiosity and direct the attention of the student to the proper sources of information on the subject. The acquaintance which I have with that law is necessarily very imperfect, and I am very satisfied that no part of it can be examined, and no one period of its history can be touched by a person not educated under that system, without finding himself at once admonished of the difficulty and delicacy of the task, by reason of the overwhelming mass of learning and criticism which presses upon every branch of the inquiry. That part of the Roman jurisprudence which has been denominated by the ancient embraced the period from the foundation of the city by Romulus to the establishment of the 12 tables. Early Roman law. The fragment of the Enchiridion inserted in the Pandects is the only ancient history of the first ages of the Roman law now extant. It was composed by Pomponius in the 2nd century of the Christian era and rescued from oblivion by Justinian, and Beinashak has republished it and endeavors to restore the integrity of the original text by emendaments and a critical commentary. From this fragment we learn that Sextus, or Cain's papyrus, who was a Pontifex Maximus about the time of the expulsion of Tarquin, made a collection of the leges regae, or laws and usages of the Romans under their kings, in which was known by the name of Jus Civile Papyranium. Very few, if any, fragments of this original collection by papyrus now remain, though efforts have been made to restore, if possible, some portion of these early Roman laws. Such a work was evidence of great progress in jurisprudence under the kings, and it must have contained an account which would have been at the present day most deeply interested and curious of the primitive institutions of a city destined to become the mistress of the world. The genius of the Roman government and people had displayed itself by the time of the expulsion of their kings, and the foundations of their best institutions and discipline had been laid. The Roman people were divided into tribes and curiae, and the patrician order and the Roman Senate were instituted under Romulus, and that last body became in process of time the most powerful and majestic tribunal in all antiquity. The general assemblies of the people were a part of the primitive government and a very efficient portion of the legislative power, and they met in their curiae or parishes, and the vote of every citizen belonging to the curiae was equal in these comita curiata. The Senate was a select body of the elder citizens, and the king was elected for life by the curiae upon the nomination of the Senate, and the laws of the comita conferred upon him the powers of a civil and military chief. The facial and other colleges established by Numa bound the Romans to religious discipline. Servius Tullius divided the people into 6 classes and 193 centuries, and this was a most important change in the Roman polity. The first class contained the patricians, knights, and rich citizens, and 98 centuries, and when the people assembled by centuries in their comita centuratia, as they generally did thereafter when called by the consuls or senate, they voted by centuries, and the first class containing a majority of all the centuries, if unanimous, dictated the laws. This arrangement threw the powers of government into the hands of the patrician order and of men of property. After the establishment of the Republic, all the higher magistrates were elected in the comita centuriata, which were convoked by the consuls, and they presided in them, counted the votes, and declared the result, and their resolutions were leges of the highest authority and binding on the whole community. After the institution of tribunes, they convoked the assemblies of the people by tribes, and there all the people met on an equality and voted per capita. In the comitia tributa, the people elected the tribunes and subordinate magistrates, and enacted plebiscita, binding on the plebeians alone, until the Hortensian law made the decrees of the people in their comita tributa binding equally on patricians and plebeians. As the whole administration of justice, civil and criminal, had been transferred from the kings to the consuls, it soon became necessary to control the exercise of this formidable power. This was done by the Valerian law proposed by the consul Valerius, and granting to persons accused of crimes a right of appeal from the judgment of consuls to the people. It then became an established principle in the Roman constitution that no capital punishment could be inflicted upon a Roman citizen without the vote of the people, though the consuls retained the power of inflicting very severe imprisonment. The Valerian law became an imperfect palladium of civil liberty, and was in some respects analogous to the Habeas Corpus Act in the English law, but the appointment of a dictator was a suspension of the law. As the royal laws collected by papyrus had ceased to operate except indirectly by the force of usage, and as the Romans for 20 years after the expulsion of Tarquin had been governed without any known public rules, they began to suffer the evils of uncertain and unsteady laws. The call for written law was a long time resisted on the part of the magistrates and Senate, but it was at last complied with, and a commission of 3 persons, by the joint consent of the Senate and tribunes, was instituted to form a system of law. This commission gave birth to the 12 Tables, which formed a distinguished era in the history of the Roman law and constitute the commencement of what has been called the middle period of the Roman jurisprudence. The 12 Tables. The 12 Tables were ratified by the consent equally of the patricians and plebeians, and they consisted partly of laws transcribed from the institutions of other nations, partly of such as were altered and accommodated to the manners of the Romans, partly of the new provisions, and mainly perhaps of laws and usages under their ancient kings. They were written in a style exceedingly brief, elliptical, and obscure, and they showed the great simplicity of Roman manners, and are evidence of a people under a rugged police and very considerably advanced in civilization. They contain a great deal of wisdom and good sense intermixed with folly, injustice, and cruelty. They were engrossed on tables of wood or brass or ivory, and were exposed to destruction, though unquestionably preserved, when the city was burnt by the Gauls. They existed entire in the 3rd, but did not, as Hegnicius supposes, survive the 6th century of the Christian era. This code obtained in the subsequent ages of the Republic from the most distinguished philosophers, historians, and statesmen, the blind tribute of patriotic veneration and the most extravagant eulogy, as being a system inculcating the soundest principles of ethics and civil polity, and surpassing in value the jurisprudence of Solon and Lycurgus, and the 10 books of the laws of Plato, and whole libraries of Grecian philosophy. As Rome increased in territory, wealth, arts, and refinement, her laws were progressively enlarged and improved and adapted to the progress of society and its increasing wants and vices. The obligation of the 12 Tables was gradually diminished or destroyed by the multitude of new regulations, and the history of Roman law from the time of the 12 Tables to the reign of Hadrian is eminently instructive. After many struggles, the patricians were obliged by the Lex Horatia to submit to the authority of the plebiscia, enacted by the plebeians alone in their comita tributa, as being of equal force with the leges passed at the instance of a consular or senatorial magistrate by the whole aggregate body of the people, patricians, and plebeians. The Senate also frequently promulgated laws under the name of senatus consulta by their own authority. A senatus consultum was allowed to continue in force only 1 year unless ratified by the common course of rogatio ad populum, and the tribunes could at any time by their veto put a negative upon any projected decree of the Senate. That body likewise assumed the right to dispense with laws, though by a law proposed by the tribune Caius Cornelius, the Senate could not exercise their dispensing power unless 200 senators were present. Within a very few years after the adoption of the 12 Tables, the prohibition of marriages between the patricians and plebeians was abolished, but the patricians had the address to retain the management and control of the whole administration of justice. This was effected in several ways. Legal forms. It was effected by the institution of legal forms of judicial proceeding called leges actiones, and by means of the pontifices who regulated the calendar and assumed the power of fixing the lawful days of business, the dies fastae et nefasti. These judicial forms and solemnities gave order and uniformity to the administration of justice, but they were mysteries of jurisprudence confined to the learned of the patrician order and locked up in the pontifical archives. They could not be changed at the pleasure of the people, and the right to interpret them belonged to the pontifical college, and the patricians had retained the exclusive right of being eligible to the offices of the priesthood. The forms remained confused and undigested until Appius Claudius Coccus, a member of the pontifical fraternity, reduced them into one collection, which his scribe, Sanus Flavius, surreptitiously published, together with the calendar or fasti, to the great satisfaction of the people. It acquired the title of the Jus Civili Flavanium, and a second collection of these legal precedents afterward appeared and was called the Jus Civile Aelianum. This Roman science of special pleading became a subject of ridicule by Cicero as being a cunning and captious verbal science, and these forms were expressly abolished by the Emperor Constantine as insidious. Praetorian law. The edicts of the praetor became another very important means of the increase and improvement of the Roman law. The judicial decisions of the praetors, or edicta praetorium, became of great consequence. They were called jus honorarium, or patrician law, derived from the honor of the praetor. There had been, from the foundation of the city, a magistrate called praefectus urbis to administer justice in the absence of the king or consul, and after the plebeians attained a share in their consular dignity, the patricians created a permanent city praetor, and they confined his province to the administration of justice. And such a magistrate was indispensable as the consuls were engaged in foreign and executive duties. The praetor was at first a patrician and elected in the Comita Centuratia, though the office in time became accessible to plebeians. Business soon required a second praetor to preside over the causes of foreigners called praetor peregrinus, and praetors were afterwards allotted to the provinces as the empire widened. Under Augustus, the praetors had multiplied to 16, and in the time of Pomponius there were 18, and one of them judged de fide commissa. Every praetor, on entering into office, established and published certain rules and forms as the principle and method by which he proposed to administer justice for the year. He had no power to alter these rules, and this jus praetorium vel honorarium tempered the ancient law by the spirit of equity and public utility, and it was termed the living interpreter of the civil law. But as the praetor was apt to vary from his annual edict and to change it according to circumstances, which opened the way to many frauds, it was provided by a law enacted at the instance of the tribune Caius Cornelius that the praetor should adhere to his edicts promulgated on the commencement of his magistracy. These praetorian edicts were studied as the most interesting branch of Roman law, and they became a substitute for the knowledge of the 12 tables, which fell into neglect, though they had once been taught as a carmen necessarium and regarded as the source of all legal discipline. Responsa prudentum. The opinions of lawyers, called the responsa or interpretenoces prudentum, composed another and very efficient source of the ancient Roman jurisprudence. The most ancient interpreters were the members of the College of Pontifices, composed of men of the first rank and knowledge. Civil statesmen and eminent private citizens followed their example and sometimes debated in the forum. Their answers to questions put were gradually adopted by the courts of justice by reason of their intrinsic equity and good sense, and they became incorporated into the body of the Roman common law under the name of fori, disputionates, and jus civile or responsa prudentum. This business, undertaken gratuitously by persons of the highest distinction, grew into a public profession, and law became a regular science taught openly in private houses as in schools. The name of the principal lawyers who became in this way public professors of the law are to be found in the work of Pomponius, and in the writings of Cicero, Horace, Tacitus, and the other authors of the classical ages. Their opinions were preserved by their successors, and fragments of them are, no doubt, dispersed in different parts of the Pandects, without the sanction of their names. Cicero speaks of this employment of distinguished jurists with the greatest encomiums, and as being the grace and ornament and most honorable business of old age. The house of such a civilian becomes a living oracle to the whole city, and this very accomplished orator and statesman fondly anticipated such a dignified retreat and occupation for his declining years. The philosophy and policy and wisdom of Greece were collected together, says Gravina, by the Roman civilians, and all that was useful introduced into the Roman law. And if it were really true that the 12 tables were not drawn by the rough agents who compiled them directly from Grecian fountains, we are assured that the omission was abundantly supplied in after ages, and the institutions of Greece were studied by more enlightened statesmen and contributed to perfect and adorn the Roman law. Age of Augustus. In the Augustan age, the body of the Roman law had grown to immense magnitude. It was composed of the leges, or will of the whole Roman people, declared in the Comita Centuratia, the plebiscia enacted in the Comita Tributa, the Senatus Consulta promulgated by the single authority of the Senate, the legis actions, the edicta magistratium, the responsa prudentum, and subsequent to the age of Cicero is to be added the Constitutio Principis, or ordinances of the Roman emperors. The Roman civilians began very early to make collections and digests of the law. The book of Sextus Aelius contained the laws of the 12 tables, the forms of actions, and the responsa prudentum. Publius Mucius, Quintus Mucius, Brutus, and Manilius all left volumes upon law, and the 3 books of the latter existed in the time of Pomponius as moments of his fame. Severus Sulpicius left behind his nearly 180 volumes upon the civil law. Many distinguished scholars arose under his discipline who wrote upon jurisprudence, and Aufidius Namusa digested the writings of 10 of those scholars into 140 books. Anticius Labeo under Augustus surpassed all his contemporaries, and he compiled 400 volumes, many of which Pomponius says he possessed. The noble design of reducing the civil law into a convenient digest was conceived by such great men as Cicero, Pompey, and Julius Caesar, though it is certain that no systematic, accessible, and authoritative treatise on the civil law appeared during the existence of the Republic, and Cicero says that the law lay scattered and dissipated in his time. The Roman jurisprudence was destined to continue for several centuries under the imperial government, a shapeless and enormous mass receiving continual accumulations, but it was fortunately cultivated under the emperors by a succession of illustrious men equally distinguished for their learning, wisdom, and probity. Before the time of Augustus, the responsa prudentum were given viva voce, and they had not the force of any authority in the forum, and the business was free to all persons. The character of these responsa was abused and discredited by the crude opinions of pretenders, and Augustus restrained the profession of the jurisconsults to such as he should select as most worthy, and they were to be first approved of and commissioned by him. They then began to give their opinions in writing, with their reasons annexed. This raised their influence and reduced the praetors to a state of comparative dependence upon those living oracles of law, who were under the influence of the emperor, and who obtained by their means the control of the administration of the law. Heinicius says that Augustus instituted this college of civilians in order that he might covertly assume legislative power and adapt the republican jurisprudence to the change in the government. He likewise instituted a cabinet council, which was called the consistory by succeeding princes. It was composed of the consuls, several other magistrates, and a certain number of senators chosen by lot. Ulpian was a member of this royal council under Alexander Severus. It was the imperial legislature. The power of the comita was transferred to this shadow of a Roman Senate, for the old constitutional Senate, not being able conveniently to govern all the provinces, according to the courtly language of the Pandects, gave to the prince the right to make laws. The judgment of the prince were called imperial constitutions, and they were usually enacted and promulgated in 3 ways. First, by rescript, or letter in answer to petitions or to a distant magistrate. Second, by decrees passed by the emperor on a public hearing in a court of justice, and Paulus collected 6 books of those decrees, and from which he, for the most part, dissented. Third, by edict or mere voluntary ordinances. Gravina says that these imperial constitutions proceeded not as from a single individual, but as from the oracle of the republic by the voice of the senators, who were consulted, and were the visible representatives of the majesty of the commonwealth. Many of these imperial ordinances were suggested by the best of the civilians, and do great honor to their authors. And with regard to private and personal rights, the Romans enjoyed to a very great degree, under the emperors, the benefit of their primitive fundamental laws, as they existed in the times of the Republic. The profession of the law was held in high estimation under the emperors, and during the 2nd and 3rd centuries the science of jurisprudence was elevated higher than it had ever been in any other age, or among any other people. Hadrian took off the restriction of Augustus and gave the privilege of being a public interpreter of the law to the profession at large. It was restored by the Emperor Severus, and the responsa prudentum assumed an air of great importance. Though in the first instance they were received as mere opinions, they gradually assumed the weight of authority. The opinions were sent in writing to the judges, and in the time of Justinian they were bound to determine according to those opinions. These responsa, of which many are preserved in the Pandects, were not of the same authority as the constitutional leges, but they were law for the case, and they were applied to future cases under the character of principles of equity and not of precepts of law. In the ages immediately preceding Justinian, the civil law was in a deplorable condition, by reason of its magnitude and disorder, and scarcely any genius, says Heinicius, was bold enough to commit himself to such a labyrinth. As a remedy for the evil, the Emperor Valentinian III confirmed by decree the writings of Papinian, Paulus, Gaius, Ulpian, and Modestinus by name, and directed that they alone be permitted to be cited in the courts of justice, with the exception of such extracts as they had transferred into their books from the ancient lawyers, and with some other qualified exceptions in favor of Scaevola, Sabinus, Julianus, and Marcellus. The opinion of the majority of these 5 legislative characters was to govern, and where there was in any case an equal division of opinion, that Papinian was to be preferred. Digest of the Civil Law. The first authoritative digest of the Roman law which actually appeared was the Perpetua Edict, compiled by Salvius Julianus under the orders of the Emperor Hadrian, and of what nothing now remains but some fragments collected and arranged by Gothfrid, and published along with the body of the civil law. Hadrian was the first emperor who dispensed with the ceremony of the Senatus Consulta, and promulgated his decrees upon his sole authority. The Praetorian edicts had been so controlled under the government of the emperors by the opinions of the civilians that they lost the greater part of their ancient dignity, and Hadrian projected the design of reducing the whole Roman law into one regular system. All that he, however, lived to perform was to procure the compilation of those edicts of the praetors, which had stood the test of experience on account of their authority and equity, and had received the illustrations of civilians. Many able professors undertook from time to time a digest of the civil law. Papirius Justus collected some of the imperial constitutions into 20 books, and Julius Paulus compiled 6 books of decrees or imperial decisions. Gregorius made a collection of a higher character, and he digested into order the chief, if not the whole, of the imperial rescripts from Hadrian down to the reign of Diocletian and his colleagues, and which was called the Gregorian Code, and attained great authority in the Forum. Hermogenes continued this collection under the name of the Hermogenean Code. Theodosius the Younger appointed a committee of 8 civilians to reduce the imperial constitutions from the time of Constantine into a methodical compendium. And this Theodosian Code became a standard work throughout the empire, and it was published in 6 folio volumes in 1665, with a vast and most learned commentary by Gothfrid. Another century elapsed before Justinian directed Tribonian, who was an eminent lawyer and magistrate, to unite with him a number of skillful civilians, and to assume the great task of collecting the entire body of the civil law, which had been accumulating for 14 centuries into one systematic code. Whether the Roman law at that period exceeded or fell short of it is not easy to determine. Tribonian represented to the emperor that when he and his learned associates undertook the business of digesting the civil law, he found it dispersed in 2,000 books and in upwards of 3 millions of verses, detached from the writings of the sages, which it was necessary to read and understand in order to make the selections. The size of these volumes and the exact quantity of matter in these verses we cannot ascertain. It is, however, a fact beyond all doubt that the state of the Roman law rendered a revision indispensable. Justinian himself assures us that it lay in such great confusion and was of such infinite extent as to be beyond the power of any human capacity to digest. Corpus Juris Civilis. The compilations made under Justinian, and which constitute the existing body of the civil law, consist of the following works, in which I shall mention in the order in which they were originally published. Code. 1. The Code in 12 books is a collection of all the imperial statutes that were thought worth preserving from Hadrian to Justinian. In the revision of them, the direction to Tribonian and his 9 learned associates was that they should extract a series of plain and concise laws, omitting the preambles and all other superfluous matter, and they were likewise entrusted with the great and hazardous power to extend or limit or alter the sense in such manner as they should think most likely to facilitate their future use and operation. Institutes. 2. The Institutes, or elements of the Roman law in 4 books, were collected by Tribonian and 2 associates. They contain the fundamental principles of the ancient law in a small body for the use and benefit of students at law. This work was particularly adapted to the use of the law schools at Berytus, Rome, and Constantinople, which flourished in that age and shed great luster on the Roman jurisprudence. It is such an admirable compendium of the elements of the civil law that it has in modern times passed through numerous editions and received the most copious and laborious illustrations. It has been a model by reason of its scientific and orderly arrangement for every modern digest of municipal law. The Institutes were compiled chiefly from the writings of Gaius, and a discovery by Mr. Niebuhr so late as 1816 of a rewritten manuscript of the entire institutions of Gaius has given increased interest to the Institutes of Justinian. 3. The Digest, or Pandects, is a vast abridgment in 50 books of the decisions of praetors and the writings and opinions of the ancient sages of the law. This is the work which has principally excited the study and reflections and commentaries of succeeding ages. It is supposed to contain the embodied wisdom of the Roman people in civil jurisprudence for near 1200 years, and the European world has ever since had recourse to it for authority and direction upon public law, and for the exposition of the principles of natural justice. The most authentic and interesting information concerning the compilation of the Pandects is to be found in the ordinances of Justinian, prefixed by way of prefaces to the work itself. In the first ordinance addressed by Justinian to his questor Tribonian, he directs him and his associates to read and correct the books which had been written by authority upon the Roman law, and to extract from them a body of jurisprudence in which there should be no 2 laws contradictory or alike, and that the collection should be a substitute for all former works, that the compilation should be made in 50 books and digested upon the plan of the perpetual edict, and contain all that is worth having in the Roman law for the preceding 1400 years, so that it might thereafter be regarded as the temple and sanctuary of justice. He directed that the selection be made from the civilians and the laws then in force, with such discretion and sagacity as to produce in the result a perfect and immortal work. And in the anticipation of the result, he declared that no commentaries were to be made upon the digest, as it had been found that the contradictions of expositors had disturbed the whole body of the ancient law. In about 3 years after the publication of this first ordinance, Justinian issued another upon the completion of the work. In the latter ordinance, addressed to the Senate and people, he declared that he had reduced the jurisprudence of the empire within reasonable limits, and within the power of all persons to possess at a moderate price, and without the necessity of expending a fortune in acquiring useless volumes of laws. He stated that in the compilation of the Pandects, Tribonian and his associates had drawn from authors of such antiquity that their names were unknown to the learned of that age. If defects should be discovered, recourse must be had to the emperor, and he pointedly prohibited all persons to have any further recourse to the ancient laws, or to institute any comparison between them and the new compilation, and to prevent the system from being disfigured and disordered by the glosses of interpreters, he declared that no citations were to be made from any other books than the Institutes, the Pandects, and the Code, and that no commentaries were to be made upon them upon pain of being subjected to the charge of the crimen falsi, and to have the commentaries destroyed. The Pandects are supposed to have been compiled with too much haste, and they were very defective in precision and methodical arrangement. The emperor allowed 10 years, and Tribonian and his 16 colleagues finished the work in 3 years. It is said that the Pandects were composed of the writings of 40 civilians, and the principal part of whom lived under the latter Caesars, and the doctrines only, and not the names of the more ancient sages, were preserved. If the work had been executed with the care and leisure that Justinian intended, it would have been an incomparable monument of human wisdom. There are, as it is, a great many contradictory doctrines and opinions in the compilation of the same subject, and too much of that very uncertainty which Justinian was so solicitous to avoid. But with all its errors and imperfections, the Pandects are the greatest repository of sound legal principles applied to the private rights and business of mankind that has ever appeared in any age or nation. Justinian has given it the venerable appellation of the Temple of Human Justice. The excellent doctrines and the enlightened equity which pervade the work were derived from the ancient sages, who were generally men of distinguished patriotism and sustained the most unblemished character, and had frequently been advanced to the highest offices in the administration of the government. The names of Gaius, Scaevola, Papion, Ulpian, Paulus, and Modestinus may be selected from a multitude of civilians as models of exalted virtue and of the most cultivated reason and philosophy, drawn from the precepts and examples of freer and better ages. It is owing to their writings that the civil law, for the purity and vigor of its style, almost rivals the productions of the Augustan age. Novels. 4. The novels of Justinian are a collection of new imperial statutes which constitute a part of the body of the civil law. Those ordinances were passed subsequent to the date of the code and had been required in the course of a long reign and by the exigencies of succeeding times. They were made to supply the omissions and correct the errors of the preceding publications, and they are said by competent judges to show the declining taste of the age and to want very much of that brevity, dignity, perspicuity, and elegance which distinguished the juridical compositions of the ancients. Some of these novels are of great utility, and particularly the 118th novel, which is the groundwork of the English and American statutes of distribution of interstates effects. The Institutes, Code, and Pandex were afterwards translated into Greek, and the novels were generally composed in that language, which had become the vernacular tongue of the Eastern Empire, and as evidence of the universality of that tongue, Justinian declared that one of his constitutions was composed in the Greek language for the benefit of all nations. Laws of the Civil Law. When the body of the civil law is contained in the Institutes, the Pandex, and the Code was ratified and confirmed by Justinian, it became exclusively the law of the land, and the various texts from which the compilation was made fell speedily into oblivion, and all of them, except the Theodosian Code and fragments of the other parts, disappeared in the wreck of the empire. The great work itself was in danger of being involved in the general deconstruction which attended the irruption of the northern barbarians into the southern provinces of Europe. The civil law maintained its ground a long time at Ravenna and in the Illyrian borders, but all Italy passed at length under the laws as well as under the yoke of the barbarians. Balunius, Atticae, Ferranus, Immanusque, Longoborgadium, leges excepted. There was but one circumstance that could give anything like compensation to the inhabitants of Europe for the absence or silence of the civil law during the violence and confusion of the feudal ages, and that circumstance was the redeeming spirit of civil and political liberty, which pervaded the Gothic institutions and tempered the fierceness of military governments by the bold outlines and rough sketches of popular representation. It was an indelible and foul blot on the character of the civil law as digested under Justinian that it expressly avowed and inculcated the doctrine of the absolute power of the emperor, and that all the right and power of the Roman people was transferred to him. This had not till then been the language of the Roman laws, and Gravina, with much indignation, charges the introduction of the lex regia to the fraud and servility of Tribonian. Be that as it may, the claim of despotism became afterwards a constitutional principle of imperial legislation. Revival of it. It has been made a question whether the Pandex were for many ages so entirely lost to the western parts of Europe as has been generally supposed. It is certain, however, that about the time of the assumed discovery or exhibition of a complete copy of them at Amalfi, in Italy, near the middle of the 12th century, the study of the civil law revived throughout Italy and Western Europe with surprising ardor and rapidity. The impression which the science of law is so perfect a state of cultivation made upon the progress of society and the usages of the feudal jurisprudence was sudden and immense. In defiance of the command of Justinian to abstain from all notes or comments upon his laws, the civil law on its revival was not only publicly taught in most of the universities of Europe, but it was overloaded with the commentaries of civilians. From among the number of distinguished names, I would respectfully select Vinnius on the Institutes, Voet on the Pandex, and Persius on the Code, together with a treatise on the civil law which abound in the work of Bankerschock, Heineccius, and Pother, as affording a mass of instruction and criticism most worthy of the attention and diligent examination of the student. Reception in England. The civil law had followed the progress of the Roman power into ancient Britain, and it was administered there by such an illustrious praetorian prefect as Pampinian, and Selden thinks he was also assisted by Paulus and Ulapian, After the Roman jurisprudence had been expelled by the arms of the northern barbarians and supplanted by the crude institutions of the Anglo-Saxons, it was again introduced into the island upon the recovery of the Pandects and taught in the first instance with the same zeal as on the continent. But the rivalship and even hostility which soon afterwards arose between the civil and common law, between the two universities and the law schools or colleges at Westminster, between the clergy and laity, tended to check the progress of the system in England, and to confine its influence to those courts which were under the most immediate superintendence of the clergy. The ecclesiastical courts and the Court of Chancery accordingly adopted the canon and Roman law, and the Court of Admiralty, which was constituted about the time of Edward I, also supplied the defects of the laws of Oleron from the civil law, which was generally applied to fill up the chasms that appeared in any of the municipal institutions of the modern European nations. A national prejudice was early formed against the civil law, and it was too much cultivated by English lawyers. Lord Coke mentions by way of reproach that William de la Pole, Duke of Suffolk, in the reign of Henry VI, endeavored to bring in the civil law, which gave occasion to Sir John Fortescue to write his work in praise of the English law, and the same charge was made one of the articles of impeachment against Cardinal Wolsey. But the more liberal spirit of modern times has justly appreciated the intrinsic merit of the Roman system. Sir Matthew Hale, according to the account of Bishop Burnet, frequently said that the true grounds and reasons of law were so well delivered in the Digest that a man could never well understand law as a science without first resorting to the Roman law for information, and he lamented that it was so little studied in England. And in Lane v. Cotton, that strict English lawyer Lord Holt admitted that the laws of all nations were raised out of the ruins of the civil law, and that the principles of the English law were borrowed from that system and grounded upon the same reason. Its merits. The value of the civil law is not to be found in questions which relate to the connection between the government and the people, or in provisions for personal security in criminal cases. In everything which concerns civil and political liberty, it cannot be compared with the free spirit of the English and American common law. But upon subjects relating to private rights and personal contracts, and the duties which flow from them, there is no system of law in which principles are investigated with more good sense or declared and enforced with more accurate and impartial justice. I prefer the regulations of the common law upon the subject of the paternal and conjugal relations, but there are many subjects in which the civil law greatly excels. The rights and duties of tutors and guardians are regulated by wise and just principles. The rights of absolute and usufructuary property, and the various ways by which property may be acquired, enlarged, transferred, and lost, and the incidents and accommodations which fairly belong to property, are admirably discussed in the Roman law, and the most refined and equitable distinctions are established and vindicated. Trusts are settled and pursued, through all their numerous modifications and complicated details, in the most rational and equitable manner. So the rights and duties flowing from personal contracts, expressed and implied, and under the infinite variety of shapes which they assume in the business and commerce of life, are defined and illustrated with a clearness and brevity without example. In all these respects, and in many others which the limits of the present discussion will not permit me to examine, the civil law shows the proofs of the highest cultivation and refinement, and no one who peruses it can well avoid the conviction that it has been the fruitful source of those comprehensive views and solid principles which have been applied to elevate and adorn the jurisprudence of modern nations. The institutes ought to be read in course and accurately studied with the assistance of some of the best commentaries with which they are accompanied. Some of the titles in the Pandects have also been recommended by Henequus to be read and reread by the indefatigable student. The whole body of the civil law will excite never-failing curiosity and receive the homage of scholars as a singular monument of wisdom. It fills such a large space in the eye of human reason. It regulates so many interests of man as a social and civilized being. It embodies so much thought, reflection, experience, and labor. It leads us so far into the recesses of antiquity, and it has stood so long against the waves and weathers of time, that it is impossible, while engaged in the contemplation of the system, not to be struck with some portion of the awe and veneration which are felt in the midst of the solitudes of a majestic ruin. End of section 40. End of Commentaries on American Law, Volume 1 by James Kent.